Your Lordship, Lordship, item 15, with the consent of the other side, this matter may be adjourned, Lordship.
Item 15.
1-5, Lordship.
Okay, why is it for orders? IA. Item 15, at the request of Ms. A. Verma, it stands adjourned for 1 week.
Hearing for the respondents.
For the respondents. 1 week.
Lordship, some more time, Lordship, because
2 weeks.
they want 4 weeks.
4 weeks. Who's filed the IA?
It is their IA, Lordship.
All right, 4 weeks.
Much obliged, Lordship.
May I please, Lordship? I beg to mention,
Counsel for the petitioner is also, applicant is also present. Yes.
beg to mention item 1, Lordship, on behalf of Mr. B. Bora. So he is not feeling well, Lordship. So,
Item 1 will come just now.
no, he has not come, Lordship. Some personal difficulties, not well. Let it be adjourned for 1 week or next week.
Item,
We have the urgency. Next week, that may be.
then don't agree. Why are you agreeing for an adjournment? Then we can't fix a date. Once a date is fixed, if you want to do a matter, do it. Otherwise, very well.
The next week, Lordship, he has not come, Lordship. Today, Lordship.
No one. We are passing it over for the day. We are passing it over for the day at the request of Ms. Arbora, matter stands adjourned for the day.
Interim order may continue for day also.
Whatever is there, it will continue. We are passing it over for the day. You fix a date
Yes.
as and when the matter, if it is not listed by next week. All right? Because we do not know whether he'll be
Personal difficulties.
he'll be able to appear before the court. Which date? Which date you want?
On Thursday.
How do you know he's not going to be indisposed?
Normally, we never mention Lordship. That's why we are mentioning on.
All right, we are fixing it on Thursday. Ask him to make alternative arrangements if required. Yes.
May I please, your Lordship? I'm praying for a listing of a matter, Lordship, on Friday next.
Why?
Why, Lordship? It is for admission. Actually, Lordship, I have information that DLC will be held in recent times, Lordship. That is
Which year? Which year?
Lordship, 22.
22.
If
All
he
right,
succeeds.
Dialogue by Friday, it is not too. Can be done. All right, Friday.
Deeply right.
May I please, Your Lordship? Lordship, I beg to mention item number 17, Lordship. Lordship, on the earlier occasion, matter was adjourned on the ground that the issue involved in the case is pending before the Honorable Supreme Court, Lordship. And issue is still it is pending, Lordship.
Who is for the respondents?
So PWD and Finance Department, Lordship. I will inform, Lordship.
No, you inform, bring them. We'll take it up. Yes, anyone in item 12, item 17?
Appearing on behalf of the government.
Some matter is pending before Supreme Court?
That was reflected in the court order, in the earlier order, Lordship.
You inform, you bring the counsels, we'll take up when the matter is called up.
Lordship.
Yes.
May it please, your Lordship. Lordship, I pray for listing of an IA already numbered also for correction of some clerical error in the.
All right.
Okay.
Friday.
May it please your Lordship. Lordship, I'm praying for listing of a matter on any date convenient to your Lordship.
Next week? What matter for what purpose?
Lordship, it's a writ petition, Lordship.
Admission.
Lordship, the matter was
For admission.
Lordship. On the last occasion, your Lordship was pleased to implead new respondents, your Lordship, in the writ petition on the applicant's behalf, your
You
Lordship.
want the matter to be listed for admission?
In orders column, your Lordship.
In orders. All right. You list for orders on
May I please, your Lordship.
17th. Yes.
May I please, your Lordship, I beg to mention for withdrawal. Tomorrow.
Withdrawal tomorrow. All right. Tomorrow.
May I please, Lordship. Lordship, I beg to mention item number 22. Lordship, we got relief and case becoming useful.
What is your name?
There was a melody.
Item 22 is connected to item 21.
Melody.
You do not want to press. You do not want to press item 22. What is your name?
There was a melody.
M. Hussain. Your name is not reflected in the cause list.
On behalf of Mr. Jay Baru.
Mr. M. Hussain, Learned
A. Hussain,
Counsel.
my lord.
A. Hussain.
Yes, my lord.
Appearing on behalf of Mr. J.I. Borbhuiya submits that the petitioner does not wish to press the writ petition any further as his grievances have been resolved. Therefore, does not seek to press the writ petition. Writ petition stands dismissed. Interim order, if any, stands vacated. Yes.
Bless me.
May please, your lordship,
Hmm.
beg to mention for listing your lordship in orders column, your lordship.
Next
Any
week,
convenient date,
next week, next week.
convenient.
Similar to lordship. Your lordship, I beg to mention item for listing admission, lordship, next week. Wednesday,
Next
lordship.
week, next week.
My pleasure, Lordship. Lordship, I beg to mention one petition for listing for orders, Lordship.
Next week.
Lordship's permission to list the matter tomorrow, my lord.
What?
My lord, the petitioner was allowed to go on voluntary retirement from 31st of January 2024. And he's on leave, my lord, till today. Yesterday, he has been informed that he'll be facing a medical invalidation vote tomorrow. My lord, when he is allowed to go on voluntary retirement, making him face a medical invalidation vote now would only lead to his loss of pension.
When was the matter fixed earlier?
My lord, no, my lord, it's a motion matter,
Fresh.
fresh motion. for
All right, tomorrow.
Tomorrow, my lord.
I'm so blessed.
You want to withdraw?
Yes, lordship.
Your name, please?
Yeah, Muslim lordship.
Huh?
Yeah, Muslim.
M. Hussain,
Yes.
learned counsel for the petitioner. Submits that on instructions that he does not wish to press the writ petition anymore. Accordingly, the same, he seeks to withdraw. Accordingly, the same stands dismissed from withdrawal. Interim order, if any, stands vacated.
Lordship, in this case, I am going to file affidavit today itself. Lord.
My lord, possibly it's not that, my lord, because pending matter of 2014.
Going to file,
Going to file already.
you're sure?
Yes, Lordship.
Just now, copy is provided to me, my lord. I also filed
MS
it. my
RB
lord.
Bora, learned counsel appearing for the PTC, submits that an affidavit will be filed today during the course of the day, copies of which have already been served on the counsel for the petitioner. Accordingly, praise for further time. Mr. M. Saronia, learned counsel for the, no, does not object. List next week, after 2 weeks,
After 2 weeks.
Maybe next week, my lord.
next week. All right.
I'll file reply, my lord.
You are appearing, Mr. Sarma Borua appears for the respondent government council.
Deeply.
Next week.
Deeply.
None appears for the petitioner. What is this matter?
My lord, the petitioner claims benefit of retrospective promotion, my lord. He was given promotion subsequently,
Hmm.
but he want to antedate his promotion. That is the effect of the promotion.
None appears. Pass it over for the time being. For the time being?
I don't think he is here. Well, Mr. Nair appears. I have seen that there is a case listed at Itanagar. Maybe he is not here. The next week.
You have not been informed.
I was not.
None appears for the petitioner on call. Mr. Counsel appearing for FCI.
Lordship.
Matter stands adjourned for the day.
I'm appealing item number 4, my lord.
Let me pass over for the time being, Lordship. And Mr. Architect is on legs in another.
All right, time being.
Maybe taken up for some time.
Why?
So the position of I think he's on legs in court number 14.
Every matter can be passed over for time being.
It was challenged to a termination order.
In which department?
NEPCO.
Who is the counsel?
Mr. Devojit Senapati, he is on legs in 14.
Time being.
Obliged, Lord.
Lordship, I wanted to see the records today, whether the petitioner, the adequate reasoning was given while promoting the juniors to the post of superintendent of food and civil supplies. He was superseded by his juniors, my lord. Lordship, without any reasons. However, a departmental proceeding was pending, for which seal cover procedure also was not adopted. Lordship may kindly see if the records is available.
Lordship, here in this case, the DPC record is sought for, call for Lordship. But Lordship, Lordship, can it fix the matter after 1 week's Lordship? I will submit the DPC record. Lordship.
The records will be provided by which department? Food and Civil Supplies.
Lordship.
He was given retrospective promotion, but not from the date of his juniors. He was given retrospective promotion. 2020. He ought to have been promoted from 19. Seventy 19, he ought to be promoted, but he was given a retrospective promotion from 7/11/2020. The subsequent DPC who did the matter in the seal cover, recommendation was in the seal cover, but earlier DPC.
Now both parties have been promoted. Only question is of seniority.
Seniority.
No, my lord, not only seniority, my lord, the pecuniary benefit also.
Naturally, seniority with effect from the date, according to you.
My lord, promotion will be from the retrospective effect.
So your position in the seniority list will be higher.
Higher, my lord. But that also not matter, my lord, because already in the verge of the.
You are asking for promotion with retrospective effect.
My lord.
Or you are asking for only the seniority.
No, my promotion from the retrospective, from the date of my juniors.
Have you made a specific prayer for that?
Yes, ma'am. Pair A, ma'am. B was subsequently allowed, my lord, by a separate treatment.
B
was allowed, my lord, by it was carved out from this petition much and subsequently allowed by the honorable court. Only A is pending.
Yes, we'll need the records only.
Lordship.
Can you put it?
Lordship, next
Already
week.
several dates.
No, next week, Lordship.
Mr. J.K. Goswami, learned counsel appearing for the respondent department, prays for further time to produce the relevant records of selection. Let the record be produced again on. Hmm? Sixteenth, 16th be produced on 16th. Mr. Paying appears for respondent number 5. Any on it?
7.
Your
Respondent number 7.
name. Your name.
W. Rahman.
W. Rahman for respondent 7.
5, 6.
Huh? Mr. Paying for 5 and 6. MS P. Sharma for APSC. APSC.
Let it be the last time, my. No further.
We'll see. We'll see.
Lords, Lord.
Yes, Mr. Nair.
I'm sorry, my lord. I just wanted I was caught in traffic. My lord.
Your friend wanted you to be in Itanagar.
My senior informed me, my lord. My lord, this matter, my lord. Actually, there is a matter arising out of the same incident, my lord. That is, my lord, the petition 4181 of 2014, my lord. Could this petition also be tagged along with that? That is for fixed for hearing.
Similar, my lord, because there may be inconsistency in the finding because that matter is listed in another court. So both the
That we can't do.
No, my lord, there we
You
have.
mentioned before that court
My-
that this matter be listed. We are passing it over anyway for the time. For the
We will make it. We will make a mention there.
Deeply obliged. And once again, my lord, I'm sorry. My lord.
No, you don't have to be. Yes, Mr. Goswami.
May it please also. This is a case regarding selection and appointment to the post of revenue solicitor, and private respondent has been appointed for selection. We have challenged his selection on two grounds. First ground is Lordship, the criteria for selection is merit, and the eligibility criteria is that he have to work in the revenue department for selection to the post of revenue solicitor in the establishment of deputy commissioner. But in this particular case, we have categorically stated the person who has been selected, he has not worked, he has no experience in revenue department, especially. That is the notification. And secondly, merit, I am the better comparing to him. Now I take your also to the advertisement. Page 17 of the petition. Lordship, the advertisement was issued by the Deputy Commissioner Nalbari on 5/7/2019. Applications are invited in prescribed format the post of revenue solicitor in the amalgamated establishment of Deputy Commissioner Nalbari in the pay scale in month, plus other allowances admissible as per provision of Assam Service Rule 2017 under Assam Municipal Law. Candidates must have at least 15 years in the Deputy Commissioner establishment in Assam, experience in different branch in general and revenue branch in particular. Applicants stating the age, educational qualification, and permanent address and experience in different branches, supported by attested copy certificate, copy of the recent passport size photograph, along with annual confidential report for last 5 consecutive years, should be reached to undersigned on or before 31/7/2019, latest by 4 p.m. Application should submit proportional with service particular to the Deputy Commissioner Nalbari. Selection will be done by the government by the General Administrative Department as per Assam Ministerial District Establishment Service to 1957 and Assam Ministerial District Service amended rule to 1999. Now, Lordship, as per advertisement, petitioner has applied for the post of selection to the post of revenue solicitor. Thereafter, Lordship, the Deputy Commissioner has forwarded the applicant names to the GAD for selection. And
Yes.
before that, Lordship, kindly see page 20 is a notification issued by General Administrative Department,
Yes.
where it has been specifically stated, Lordship, the selection to the post of revenue solicitor. Page 21 is the relevant portion.
Please read 21.
Page 21, relevant portion. Lordship, under subdivision shall be on the basis of assessment of annual confidential report of every eligible candidate, other relevant service record, and not on other basis such as interview or viva voice. There is
What does the rule say?
Rule says same thing. Lordship.
Show us the rule. Show us the rule. Rule to
Assam Ministerial District Service Rule. Lordship, rule has also annexed, Lordship.
Is annexed.
Lordship, page 30, page 12 onwards.
It's 12.
Page 13, Lordship, relevant portion. Rule 4, Lordship. This is the amended rule. In sub-rule 1, before concerned word, so that the word revenue shall be inserted. Hereafter, Lordship, for the purpose of selection, shall be selection board consisting of following members: Secretary to the Government of Assam General Administrative Department, Commission of the Concerned Division member, DC of the Concerned Division member, Deputy Secretary to the Government of Assam General Administrative Department, Member Secretary. Appointing authority shall advertise the vacancies, inviting application from suitable person fulfilling the requirement of the post. Appointing authority concerned shall obtain annual confidential report for last 5 consecutive years and relevant service particulars of eligible person for recruitment to the cadre of revenue solicitor, and shall furnish to the selection board annual confidential report and other relevant service particulars of the eligible person along with approximate number of vacancies likely to occur during the year. Board shall examine the annual confidential report and relevant service particulars of the person, taking into consideration the merit of the person, and prepare the list of names in order of preference for recruitment to the post. So merit is the only criteria for selection to the post of revenue solicitor. And that has been clarified by the GAD, by the notification which I placed on page 20 and 21. There is no interview, there is no viva voice. Only on the basis of annual confidential report. Lordship, the original copy of the Lordship, the selection process is page 22, which has been typed copy I have shown. Page 22 is the original copy. Selection or appointment to the revenue solicitor, head agent in the amalgamated establishment of Deputy Commissioner's office. Here, Lordship, strictly on merit for appointing the post of revenue solicitor or head agent. Middle portion. Type copy I have already read.
Yes.
Hereafter, Lordship, appointment order, page 24. The private respondent has been selected and appointed. That is under select. Subject to the division without any notice assigning in the region, thereof, the recommendation of the selection board selection candidate to the post of revenue solicitor, Umesh Chandra Das, senior assistant, Deputy Commissioner Nolbari in the post of revenue solicitor in the amalgamated establishment of Deputy Commissioner Nolbari in the minimum per month, posted in the office of the Deputy Commissioner Nolbari against existing vacancy with effect from date of taking of the charge. Lordship, that is under select. Now, Lordship.
Yes.
Petitioner has.
Who's appearing for Umesh Das?
Umesh Das is the private candidate. He is appearing.
Mr. Ali is appearing.
I have filed affidavit.
Hmm.
Lordship, we have applied under the RTI regarding the information of selection. And the information has been provided to us. Page 26 is the RTI information. Page 26. Now I'll take you Lordship to the directly to the RTI information. Page 29, Lordship. Page 29 is the statement of detail of candidate who applied for the post of revenue solicitor under amalgamated establishment of Deputy Commissioner Nolbari. Lordship, got it. First one is Umesh Chandra Das, who has been selected and appointed. Lordship will find 5 years ACR from 2014-15 to 2019. 2014-14 Umesh Das, good Lordship. My case, Lordship, next Bhubaneswar Sharma. He is very good Lordship, got it. Next 2015-16, very good, good. My concern is very good. Lordship, good.
Hmm.
Next Lordship, 16-17, good, very good. And my case was very good. 17-18 is very good, good. 18-19, good, very good. I am very good. Lordship. Now, Lordship, remarks. An inquiry is conducted regarding educational certificate, etc. of the copy of the inquiry report is enclosed here. It's not relevant now. Now, Lordship, there is another error. The minutes of the selection committee, page 31. May I take a look, page 31?
Yes.
Now, Lordship, as per the rule, service rule, who are the member of the selection committee, Lordship will find original copy at page 32.
Yes.
Lordship will find Secretary of Government of Assam has present, Deputy Commissioner present, Under Secretary present, and Divisional Commissioner LED, Lower Assam Division, he is SO to the concerned division.
Is?
SO.
What is SO?
Sectional officer. Not the person who has been notified as a member, he was not present. SO was present in this election.
Who is the person notified?
Notified, Lordship, as per notification, Lordship will find page 14, Lordship.
1-4.
1-4.
Yes.
Lordship is Secretary of Government of Assam, page 14. Secretary of Government of Assam, consisting of following members: Secretary of Government of Assam, General Administrative Department Chairman, Commissioner of the concerned division member, Deputy Commissioner concerned division member, Deputy Secretary of Government of Assam, General Administrative Department member secretary. Now, Lordship, the Commissioner B, Commissioner by concerned division is a member, but here SO has been deputed as per affidavit filed by the GAD as well as Government Deputy Commissioner. He was been, Lordship, entrusted the duty to be selection committee's member, violating the rules. Now I'll take your Lordship. What is the stand of the government as well as the GAD in this regard? Lordship will find GAD's affidavit from page 34 onwards. Page 39 is a relevant portion, para 12.
Yes.
Lordship. With regard to the statements made in paragraph 13 of the writ petition, contains on the petitioner that the selection of Umesh Chandraji is not legally sustainable is denied. Answering dependent respondent begs to state that meeting dated 8/28/2023 for selection of revenue solicitor was attended by SO of commission, admitted. SO of the commissioner Lower Assam division, as he was authorized by the divisional commission. LED to attend a meeting and the context of SO to commissioner Lower Assam division informed.
But it's an authorized officer.
He cannot be authorized behind the rules. Rule has not given any power to the commissioner to represent the member. Because rule has not said that the Lower Assam commissioner can appoint any other person to be member. Because service rule said Lower Assam commission. That is one of the ground, Lordship.
All right.
Now I'll take your Lordship. Para 16, page 40.
Yes.
Page 41 is the relevant portion. They have stated that there is no provision for calculating marks on the basis of ACR. That with regard to the para 17, with regard to the statements made in paragraph 19 of the petition, answering deponent humbly begs to state that as per Assam Ministerial District Establishment Service Rule 1967, there is no provision for calculating marks as per marks given in the ACR. They have denied against the rule, against the notifications by GAD. That with regard to the statements made in paragraph 20 of the writ petition is denied. Answering deponent humbly beg to state that there is no provision for calculating marks as per marks, remarks, and respondent number 4 works in the revenue sector. They said respondent number 4 work in the revenue sector, revenue branch. That is the only statement. Now they have annexed Lordship the how he has been special officer has been entrusted the duty. Annexer 1, page 43. With reference to the above, I am directly informed that Commissioner of Lower Assam Division, member of the selection committee, has authorized special officer of the Commissioner of Lower Assam Division to attend the meeting of the selection board for selection and recommendation to the post revenue solicitor in the amalgamated establishment of Deputy Commissioner and all that.
So he's not a section officer, special officer.
Special officer. These are the office notes. Next page.
Now, how has it prejudiced you by not
that is
having
one of the ground. That is one of the ground, but he cannot be be substituted. Lower Assam Commissioner cannot be substituted, violating the rules, because Lower Assam Commissioner is the member. How SO can be authorized?
No, he is representing the Lower Assam Commissioner.
Lordship, representing.
Whether rules have said, but then given on a particular situation,
without
the
going,
bar
without going
for
to
a
the
competent officer to be representing that office, unless you say he's not otherwise competent.
Not competent otherwise, Lordship. Rule specifically stated that Lower Assam Commissioner is to be the member.
All right.
But he has authorized. This is not my case, Lordship. My case is regarding merit only. But I have shown my every ground, Lordship.
Okay.
Now to the affidavit of the Lordship, respondent number, Deputy Commissioner's affidavit, page 34. Page 34. Now, para 12, page 37. Same thing has been stated that with regard to the statements made in paragraph number 14 of the petition, deponent beg to state that from the minutes of the selection board, page 31 of the petition, it does appear that an exercise was undertaken regarding ACR and other service particulars of the candidate. But I have already, Lordship, shown this minutes of the selection committee. There is no assessment of merit. And regarding, Lordship, the working, what I have stated in para 20 of the petition, that
yes,
para 20 of the petition, we have stated that Umesh Chandra Das has no experience regarding revenue branch. And that has been replied at para 16, page 39.
Yes, please continue.
Page 16. With regard to the statements made in paragraph number 20 of the petition, deponent begs to state that Umesh Chandra Das worked in the relief branch of Nalbari Revenue Circle, excise branch, loan branch, sub-register office, Nalbari, record keeper of revenue branch, Bhubaneswar Sharma worked in the following branch: SDPL branch, land acquisition branch, DM branch, administrative branch, personal branch, and Bhograpa Revenue Circle. Regarding the revenue branch.
Yeah.
Others are not relevant. Now I take a
Are there any eligibility criteria? Is there any eligibility prescribed that you'll have to put in that many number of service? Is it prescribed under the rule?
Prescribed. 15 years of service in revenue as a indeed Deputy Commissioner establishment, especially in revenue branch. Advertisement also said, Lordship, page 16 again.
Yes.
Revenue branch, page 16, Lordship. Revenue branch in particular. Candidate must have 15 years in the Deputy Commissioner's establishment in Assam, experience in different branches in general, and revenue branch in particular.
Yes.
Now I will take your Lordship. The same thing has been by the Lower Assam Commissioner. Page 46 is the affidavit of the Lower Assam Commissioner.
Yes.
Page 46 is the affidavit of Lower Assam Commissioner affidavit.
46.
6.
Yes.
At page para 5, Lordship, they have admitted that the special officer of the commissioner has been attended the meeting.
Page 46.
Page 48, para 5.
48. Which paragraph you are reading?
Para 5, Lordship. The commissioner of Lower Assam Division SS Meenakshi Sundaram IAS, member of the selection committee, had authorized special officer to the commissioner Lower Assam Division to attend
You
the
are
meeting.
reading from the affidavit.
Reading for the affidavit para 5, Lordship, para page 48.
Whose affidavit is this?
This is Lower Assam Commissioner. Respondent number 2.
Respondent 2.
Lordship, got it.
Yes.
Para 5.
Hmm.
It is admitted that he authorized Lower Assam Commissioner has authorized special officer to the Commissioner of Lower Assam Division to attend the meeting.
Hmm.
At para 6, they have stated that exercise did appear to be undertaken as regard to the ACR and other service particulars of the candidate regarding Lordship assessment of merit. Now, Lordship, the affidavit filed by the private respondent. What is his stand, Lordship? He has 2 stands in the petition. Page 69.
Yes.
That with regard to the statements made in paragraph number 14, 15, 16, and 17, deponent beg to state that selection and appointment to the deponent respondent number 4 has been made after examining the service particulars and ACR for last 5 years. The petitioner has suppressed regarding his remarks in the ACR from the comparative statement as annexed by the petitioner by Annexer 6, page 27 of the petition. There is clear gap of 15 months with effect from 15/7/16 to 19/10/17 in the ACR. There is no remark in the ACR report for the aforesaid period. On the other hand, for the period of Iman to Iman, there is no remark against the ACR, but writ petitioner intentionally put the remarks as very good in the type copy. That is the allegation. I have, Lordship, already shown the RTI information. This is not my, Lordship, the written information, that is an RTI information. Again, I will take your Lordship to the service particulars forwarded by the Deputy Commissioner, which has been received by the petitioner. Page 29, Lordship. Page 29 of the petition. That is an information received under the RTI. Lordship will find this is file number Iman, dated Iman. And this is a showing details of the candidates who applied for the post of revenue solicitor under amalgamated establishment of Deputy Commissioner Nalbari. This is an RTI information. And Umesh Das is the first one, and second is Bhubaneswar.
Yes.
So I have annexed the information which has been provided under the RTI information. And Lordship will go through the relevant record of the selection minute. How, Lordship, they have considered the merit. This is an RTI information where I have shown that my information has been provided as a very good from day one for 5 years.
Your name is Bhuvaneshwar.
Bhuvaneshwar Sharma. I am very good in all respects.
And the private respondent is?
Good.
What is his name?
Umesh Chandra Das. First one, Lordship. Page 29.
Yes.
First one.
Yes.
Now he has projected that there is a no remark for ACR and very good. Petitioner intentionally put the remark as very good in the type copy. This is not my type copy. This is an information provided by the GAD, Lordship. Now, Lordship, deponent further page para 8, Lordship, page 70. Deponent also submitted RTI regarding ACR of the petitioner, and from the information submitted by the authorities found that there is a gap of ACR from a period of Iman to Iman also. Associate fact has not been brought to the notice of the Honorable Court. Therefore, there is no anomalies in the selection of the deponent. As such, writ petitioner has no merit and liable to be dismissed. They said there is no ACR for period 2014 to 16. But Lordship will find
Page 29.
Lordship.
Page 29.
Page 29 is the information provided. By GAD as submitted by the Deputy Commissioner. Same thing has been stated, Lordship, in page 71. He has stated there is no criteria for assessment of ACR.
Yes, okay.
Page 71. Same thing has been stated. There is no criteria for assessment of merit on the basis of ACR. With regard to the statements made in paragraph number 19 and 20 of the deponent, beg to state that under Assam Ministry District Assessment Service Rule 1967, there is no criteria for assessment of ACR as projected by the writ petition. The ACR of the writ petitioner shows clear gap for a period of 15 months, no remark for another 14 months. Therefore, he secured less mark than the deponent. Lordship will consider the merit assessed by the authority.
Yes.
Second ground has been taken, and regarding Lordship the
Yes, please.
regarding Lordship the revenue branch, I have stated as per advertisement he have to work in the revenue branch in special. We have stated in para 20 of the writ petition that person should have. May I take you Lordship to the para 20 of the writ petition?
Yes.
What we have stated and what reply
Para
has been
20 of?
writ petition page 8.
Yes. Yes.
If circular of the personal department is followed, present petitioner will secure 10 marks in the ACR for 5 years consecutive.
Where is the circular?
I will produce Lordship.
Is it not part of the pleading?
No, Lordship. Because it is the department, Lordship. I have asked for. Petitioner will secure 10 marks as per ACR for 5 years continuously recorded is very good. But in the case of private respondent, ACR for 3 years has been good and 2 years it was very good. So he will secure 7 marks in total. But petitioner will secure 10 marks. Besides this, present petitioner better experience in different branches in general and revenue branch in particular. Private respondent herein did not possess such qualification and experience as he did not work in revenue department at all. Private respondent worked for some time as a record keeper in revenue department. As such, private respondent did not have the experience in revenue department at all. Lordship,
Yes.
what has been replied at page 71? Page 71. Lordship.
Yes.
Para 20 has been replied at page 71, para 10.
Page 71.
Page 71, para 10 is the reply of page para 20. Lordship.
Yes.
That with regard to the statements made in paragraph 19 and 20, Deponent beg to state that under Assam Ministerial District Establishment Service Rule 1967, there is no criteria for assessment of ACR as provided by the writ petition. The ACR of the writ petitioner shows clear gap for a period of 15 months and no remark for another 14 months. Therefore, he secured less marks than the deponent. Writ petitioner tried to mislead the honorable court by suppressing the aforesaid fact filed in the writ petition. Therefore, writ petition is liable to be dismissed. There is no averment, Lordship. There is no denial that he worked in the revenue department.
All right.
Now, Lordship, another stand has been taken that as per Rule 12, there is a provision for appeal. That is why present writ petition is not maintainable. That para 11, Lordship, they have stated that writ petition is not maintainable as there is specific provision for appeal under Rule 12. Now, I'll take you, Lordship, to the Rule 12 of Assam District Establishment Service Rule 1967. This is not for selection or appointment. Every member of the service shall have, Lordship, got it?
Yes.
Shall have right to appeal from orders of the deputy commissioner or to the commissioner from the order of the commissioner to the chief secretary. This is not the, Lordship, the selection.
Who has given the order of promotion?
Order of promotion has been given by the commissioner.
Then?
This is not selection, Lordship. This is regarding order, appointment. If appointment is said to be challenged, this is the High Court forum, Lordship.
No, appointment is
There is a
pursuant to
option.
the order of commissioner.
Commissioner. Order of commissioner, this is not regarding, Lordship, appointment. This is not regarding appointment, election, selection and appointment.
But does it, what orders are contemplated under Rule 12 according to you?
Every member of the service shall have right to appeal from orders of the deputy commissioner to the commissioner for orders of the commissioner to the chief secretary.
What orders?
Orders mean any order passed by the deputy commissioner regarding transfer or other thing, everything that can be. But there is no provision for selection and appointment. I have to apply to the deputy commissioner or commissioner. Here the commissioner is the, Lordship, the member of the selection committee. How can he appeal, here appeal, Lordship?
Commissioner means?
Commissioner GAD. And another.
Yes.
Another stand has been taken by the private respondent that I have participated in the selection process, so I cannot challenge this selection.
Yes.
Lordship, the first judgment 2012 1GL377 para 19, Lordship. That is one of the grounds of the private respondent that I have participated in the selection process. That is why I cannot challenge the selection process. Para 19.
Yes.
It is unlikely that writ petitioner respondent number 7 was aware of the letter of the department minister at the relevant times, and particularly at the time of institution of the writ petition. His omission to mention about the same in the pleading at the point of time thus cannot non-suit him on this ground. Decision of this court in Manindra Das Sharma is also no avail to the appellant. It is no longer res integra that candidate participating in the selection process is not debarred hereafter to question validity thereof if same suffers from apparent illegalities rendering it non-est. Plea of estoppel against the petition respondent does not appeal to us.
Okay. Yes.
And another ground was taken that I have not implemented all other candidates who has participated in the selection process. That has been reported, that has been clarified by the Supreme Court in 2024 SCC, page 86.
Paragraph.
Paragraph number 77, 78 also.
Yes. Yes, please.
Lordship. Whereas a present case with para 78, Lordship, where the petitioner were not aggrieved by any qualification as prescribed in the advertisement, the cause of action had arisen to them to seek judicial review only when the person who do not fulfill the essential qualification were included in the select list. Further, before issuance of appointment letter dated demand, appearing corporation had made statement that no final decision will be taken in a pursuance to the advertisement dated demand. There is no more
reading from para 78.
78, 79. From 77 onwards, it is the relevant, Lordship. I am not reading para 77. Para 77.
Yes.
Sri Deva placing reliance to contenders that the candidate who have participated in the process could not have been allowed to challenge the selection. Court in para 13 and 19 laid down the following. Law on the subject has been crystallized in several decisions of this court. That this court laid down the principle that when a particular candidate appeared in the examination without objection and subsequently found to be not successful, a challenge to the process is precluded. Question of entertaining a petition challenging the examination would not rise when the candidate has appeared in the and participated. He or she cannot subsequently turn around and contend that the process was unfair and there was a lacuna therein, merely because result is not palatable. It is also well settled. Those candidates who had taken part in the selection process, knowing fully aware the procedure laid down therein, were not entitled to question the same. The same view was reiterated in who have taken part in the selection process, knowing fully aware of the procedure laid down therein, are not entitled to question it upon being declared unsuccessful. Now, Manish Kumar's case, we also agree with the High Court that after having taken part in the process of selection, knowing fully aware that more than 19 marks has been earmarked for Viva Voice test, petitioner is not entitled to challenge the criteria for process of selection. Surely, if petitioner in this name had appeared in the merit list, he would not have been deemed to challenge the selection. Petitioner invoked the jurisdiction of the High Court under Article 226 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commissioner. It is conducted that petitioner clearly disentitled him from questioning the selection, and High Court did not commit any error in refusing to entertain the petition. Reference to this connection may be made in the judgment in Maniman. Candidates who have participated in the selection process were aware they were required to possess certain specific qualification in computer operation. Applicant had applied to the selection process and after participating in the interview, sought to challenge the selection process as being without jurisdiction. This was held to be impermissible. Next, State of Uttarakhand was participating in the examination held the pursuant to the advertisement. This court held that if they have cleared the test, the respondent would not have raised any objection to the selection process or to the methodology adopted. Having taken the chance of selection, it was held that respondents were disentitled to seek relief under Article 226 and would be deemed to have aware of the right of to challenge the advertisement. It is settled law that the person who has consciously takes part in the process of selection cannot thereafter turn around.
This is not a dispute anymore.
Lordship, in this particular, Lordship, not dispute. So
Yes.
these are the main ground. Lordship will kindly see.
So essentially, your ground is that there was no process for evaluation of merit on the basis of
merit only. There is no
ACR or anything else.
There is no Viva Voice.
And the fact that there was a shortfall of recording in the ACR as far as you are concerned is denied by the records. It's not supported by the records. And there is no appellate forum because the commissioner himself was a member. These are largely your three arguments. Anything else?
Lordship kindly see the record of the
No, we'll
selection
see,
committee
we'll see.
and minutes.
We'll see. Is there any other arguments that you want to formulate besides these three? You will have a right of rejoinder. Let us hear them. Thereafter, if you require, you can argue in rejoinder.
I have downloaded how to assess the merit from the state government notification issued by the personnel department, but I could not procure the total document how to assess the merit. But I have procured the how SCR has been considered for assessment of merit in other selection process, where very good how marks to be awarded, for good how marks to be awarded. This is a personnel department notification, and that
No,
has been
this is not about ACR markings. This is about evaluation on the basis of the ACR marking.
ACR marking.
No, you are not questioning the ACR markings.
I am questioning because selection have to be made not basis of interview, not basis on Viva Voice.
Is it your case that the marks given to you are lesser or given to him are higher in the ACR? That is not your ground.
My ground is my ACR.
Your ground is that your ACR, according to you, are better or at least as good as him, if not better. How the department has evaluated this ACR is not relevant from the minutes. That is your case. Yes.
Secondly, Lordship, in other selection process of though it is for engineering department, as per OM, grading points of ACR will be allocated as below.
But it is not a part of the record.
Not part of the record.
You have to bring it on the part of the record.
We'll have to be produced by the department only.
We'll see what they want to say. Yes. You are representing
the deputy commissioner, Lordship.
Who is this? Who's in the selection committee?
Lordship, GAD is the appointing authority, Lordship.
GAD.
Yes, Lordship. But at the same time, Lordship,
yes.
Before going to the record, Lordship, regarding Rule 12, Lordship, it is the right of appeal, Lordship. Here in Lordship, the orders of the commissioner to the chief secretary, Lordship. It is not there have some alternative remedy, Lordship.
All right.
Yes, to the chief secretary, Lordship. And therefore, the order passed by the commissioner, this is the order passed by the commissioner, this is the appointment order, Lordship, and the commissioner secretary, Lordship. And now, Lordship, they have the opportunity to appeal before the chief secretary. The law provides, Lordship. In that case, the petitioner is silent, Lordship. In his petition, there is no plea regarding.
No, he has submitted that since the commissioner is a member of the selection committee.
Yes, Lordship. Chief secretary is the appellated authority. That is, chief secretary is the appellated authority.
No. Under the order of appointment,
yes,
is passed by whom?
Lordship, commissioner secretary.
Commissioner
Secretary, Lordship.
So, from the orders of
appellated authority, chief secretary.
Chief secretary. Okay.
Yes, there have the opportunity is there. They cannot go on that line, Lordship. Under Rule 12.
Yes.
Now, Lordship, the advertisement itself states, Lordship, 17, page 17. The SCR is not the sole base for selection, Lordship. Selection is the Assam has experience in different branches of general, and revenue branches in particular. Now, Lordship.
No, that's all right. That is the eligibility.
Yes, Lordship.
Question is, how has the selection been made?
Yes,
what is the
that will provide the record. So GAD will address
what
on
we
that.
want to find out. You satisfy us on that.
Yes.
Yes, GAD.
Please, Lordship. Lordship, on the last occasion, your Lordship had asked me to bring the records. I've accordingly brought the records, Lordship, and would like to place certain things, Lordship, just before producing the records. First of all, your Lordship, we are governed by the Assam Ministerial District Establishment Service Rules 1967. Here, Your Lordship, will first come to 8.1. That is the post of administrative officer, Lordship. 8.1, 8I, small subclause 1.
8.1.
Yes, Your Lordship. Which
You
is
are
under,
referring to ministerial district.
yes, Your Lordship, this, the, regarding the post of administrative officer and also this thing laid down.
In the rules we have 8 is a gradation list.
The small 8, Your Lordship, under rule 6 recruitment, under rule 6 within bracket 8I. The post of administrative officer.
All right.
So this is the this thing for administrative officer, Your Lordship. That means 15 post of administrative officer shall be filled up by selection or from amongst persons who have served for at least 15 years in any deputy commissioner's establishment and having working experience of different branches in general and in the establishment branch in particular. Now, Lordship, I would like Your Lordship to come to the next page. 8.1.3. Here the procedure is given as to how selection is made. 8.1.3.
8.1.3.
Appointing authority shall
8.1.
8.1.
It is 8.3.
8.3. I mean, 8.3.
Yes.
Appointing authority shall advertise the vacancies
Yes.
by itself or may instruct the DC concerned to advertise the vacancies, inviting application from suitable persons eligible for appointment in the post of AO, fulfilling the requirement of the post as per clause I. Appointing authority shall obtain annual confidential reports for the last 5 consecutive years and relevant service particulars. Lordship will note here, last 5 consecutive years ACRs are important as well as relevant service particulars. Lordship. So first of all, one has to have 15 years experience to come into the zone of consideration. In this case, Your Lordship, the petitioner has joined on 28/8/1990 and the private respondent has joined on 4/4/1990. That means they have completed 15 years on 4/4/2005. That means the private respondent is senior to the petitioner. And the petitioner has completed his 15 years on 28/8/1990. Thereafter, my lord, after the seniority is thereafter the ACR annual confidential reports for the last 5 years is seen and relevant service particulars. In relevant service particulars, my lord, the important thing will come regarding where they have worked. That, like for example, for the post of revenue assessor, they have to have experience in revenue matters. Now, Your Lordship, that criteria has been given here. Your Lordship, if Your Lordship comes down below 3, there is 4. Below 4, there is 5, and then after that, Your Lordship, note. There is a note. Has Your Lordship got?
Rule number?
It's not rule number. It's just given note.
No, page number?
Page it's 498 in my book, Your Lordship. It's just below the 3 which I just now read, Your Lordship. 3 below 3 there is 4. 8.4, 8.3, then 8.5.
Then note, yes.
Below there is a note. The rank and status of post of administrative officer shall be equal to that of the revenue shareholder. Your Lordship got it? So both the ranks are same, but my lord, the job description is different. They've given here 2 job description of AO and revenue share shall be as follows. Number 1, for all revenue matters will be looked after by revenue share. That means, my lord, this post is for revenue share. They have to have experience of revenue matters. So for that, all revenue matters will be looked after by revenue share. And second, administrative officer will look after the following subjects: personnel branch, magistrate branch, and planning and development branch. So here in this case, the crucial thing is that they have to have revenue matters experience. Now, Your Lordship, I've got the record over here. Looking at the record, I have gone through also, Your Lordship. I will show it now. That, my lord, the petitioner has got less experience in terms of revenue matters compared to the private respondent. If I, Lordship, I'll just place it. So here, Lordship has got page 418, service record.
Hmm.
Lordship, here, this is of private response number 4. Here, if your Lordship sees at the serial number 12, work experience in brief in various offices, branch showing period specifically.
Hmm.
The first serial number 1, branch, relief branch. This person has worked in the relief branch, Lordship, in the relief branch, which comes under the disaster management, which is under the DC establishment revenue from 4/4/1990 to 9/12/1995. Period 15/8 to Lordship. The period also is given. How much is here? Second, he has worked in the personnel branch. This, of course, is not revenue. 20/12/1995. Then, your Lordship, if your Lordship sees serial number 3, he has worked in the circle revenue. That means he's worked in the circle offices. Circle offices of the revenue department. In the this thing, your Lordship. Then, your Lordship comes to excise branch. This, of course, is not revenue. Then, your Lordship, he has worked in the Hoop Nolbury development block. This is a revenue again. It's a block. Then, your Lordship comes to the next 6, circle office again, revenue, Nolbury. He's worked there. Then after that 7, loan branch. Loan branch again is not revenue, of course. Then after that, your Lordship, 8, sub-registry, Nolbury. Sub-registry is totally revenue because they deal with mutation and all that kind of related works. Sub-registry, I mean, marriage, registration, I'm sorry. Registration, I mean, registration and stuff, your Lordship. Sub-registry. Then after that, your Lordship, circle office again, your Lordship, 9, revenue. That is again regarding mutation and everything, your Lordship. 10 is accounts branch. This is not revenue. And last is Lordship 11, that is revenue Kanango branch. This also is same revenue branch.
What is loan?
Which one, Lordship?
Loan.
Loan is Lordship. That is not a revenue branch. That is, I think, regarding some other branch, but it's related to that.
Okay. Accounts.
Loan. Accounts also is not revenue.
Then what is the last one?
Revenue Kanango branch. Kanango. Kanango. Revenue Kanango branch. That also is revenue. So, Lordship, this is the experience regarding the respond number 4. As per the that note which is given here, job description, all revenue matters will be looked after by revenue matters. So basically, the 15 years experience is required, ACR grading and service particulars. So in his service particulars, revenue matters, he has got experience.
So what is
now?
How do you calculate the 15 years?
15 years is calculated, Your Lordship, from the date of appointment. 15 years, he has joined in 4.
Is it mentioned in the period?
Yes, Lordship, it's given here in general. Because the posts are same.
What is the meaning of this column period?
Period. Yes. Oh, Lordship, here, work experience in brief in various offices. Lordship, from period meaning, Lordship, from the time he has worked from this in one branch.
Gives the idea of who has worked under what department for how many years.
Exactly. And then, Your Lordship, will come to page 478, Your Lordship, of the book, of the record. 478 is the petitioner's service record. Biodata of Sri Bhubaneswar Sharma.
Yes.
Supervisory assistant.
Wait.
470. I've marked it in blue, Your Lordship. Blue mark.
Yes.
Lordship, first, if your Lordship sees Bhubaneswar Sharma, he's worked from 28/8/1990 to 13/12/1990 in accounts branch. So first is accounts branch. Second, he has come to land reforms branch, which is 1/1/91 to 31/3/91. This is, of course, revenue, land reforms. Third, he has come to SDPL branch. This SDPL branch is a part of the Panchayat and election, Panchayat and Revenue Department. So that is not revenue branch.
Which one?
SDPL, third one, where he has worked from 1/4/91 to
land comes under?
Land comes under revenue. Land is one revenue.
Accounts is not revenue.
Not revenue.
SDPL?
SDPL is under the Panchayat and Revenue Department. I had inquired. So that does not come under the, that is under the Panchayat election. So that is not under the revenue branch.
Okay.
Then next is CA branch. CA branch is, Your Lordship, confidential branch, which is of the, like when the DC has a confidential branch.
Is it under revenue or not?
No, it's not. CA branch is confidential branch. All the letters and all that, Lordship.
All right. Then
after that, land acquisition branch. This is revenue. Then, Your Lordship,
DM
branch.
Revenue.
This is not revenue. Lordship.
Disaster management?
Oh yes, Lordship. This is revenue branch. This is revenue. Disaster management. Then after that, land acquisition branch, another, that is revenue.
Revenue.
Then next is administration branch. That is not revenue. Then there is personnel branch. This is not revenue. Then there is land acquisition branch. This is revenue. And last is again the panchayat election. So this is not revenue. So based on these particulars, election, and they have select the committee, which is the selection board, looking at the ACRs as well as these service particulars, has selected the private respondent. This is it transpires from the records. That's what, comparing both, because they saw the 15 years, and moreover the private respondent is senior to the petitioner and has got more experience. So on that basis, they have selected him. As far as this thing is concerned. Minutes is at page 675. Minutes. The original.
Why the period is reflected in a different manner here? Here you have given the period from which date to which date?
Regarding the ACR, the ACR is because the Lordship, the DC gets changed. I asked on the last occasion, Lordship had asked me.
No,
why does the periods different twice?
Then how many years he has served under revenue? How do you have how has it been calculated?
So Lordship,
where is it calculated?
1191 to 31391, he served in the land reforms department.
We know that, but
that is
somebody has to calculate and say that it
that
is
is
15
actually
years
done.
of
Lordship, what happens is the ACR grading is given. The ACR grading is done by the DC concerned. So DC grades it according to the service particulars as well as this thing. So that part they will have to answer regarding the grading of the ACR. And the Lordship, they look into this only. They look into all this, and the dates which you had asked, your Lordship, on the last occasion also. This is because the DC gets changed, so that's why they are. If you see, Lordship, in one period there are two very good. So what happens is that the DC was changed. That's why the other DC comes in and he also gives in his report. So that is why the this thing. And on that basis, they check the service particulars of the particular person. They see his seniority. They see his overall experience and his work and his efficiency. On that basis, they grade him. And then, my lord, they have accordingly selected the Umesh Das because they found him more suitable for the position, being senior, and he's completed 15 years before him also. Of course, that is not a criteria like that, because both qualify for both are eligible for the zone of come under the zone of consideration. But he has turned 15 years in 4/4/2005. Whereas he has turned 15 years in 28/8/2005, August. So looking into all these aspects, Lordship, I feel that is why the selection board has.
Your feelings are irrelevant. How the selection committee has done it, that is irrelevant.
Because if your Lordship sees the minutes, they have not given the details as to why they have given. But looking at the records, my lord, I am commenting. Rest I leave it to your Lordship. And moreover, your Lordship, regarding Rule 12, they already have an alternate remedy. They can easily approach. They were always open to approach the Chief Secretary, because the appointment was given by the Commissioner and Secretary. And Chief, there is already a specific statutory provision which provides that in case of a grievance, there is a mechanism set up to approach the Chief Secretary. Without doing that, they have directly come to the court. That aspect also has to be looked into. What a point. Okay.
Yes.
One more point I just want to point out, whether I don't know if it'll stay effective in this case. If your Lordship comes to Rule 11.
Yes.
Rule 11 of the Assam Ministerial District Establishment Service Rule 67, which is the seniority. In Rule 11.5, it says in the revenue Shahidar cadre, Rule 11 subclass 5.
Yes.
In revenue Shahidar cadre, the seniority shall be according to the date of appointment. Literally, I think after the appointment, after appointment, no, this won't come.
Yes.
That point was there. That's all, man.
Yes, Mr. Ali, anything?
May please, Lord. In this case, my lord, we have filed our affidavit, and my learned senior friend has already read out, my lord.
You made a statement in your affidavit that he has suppressed something about his
My lord.
ACRs. On what basis are you making this statement?
Case 27, my lord.
27. Yes.
Case 27, this is the statement of ACR of last 5 years, my lord. Now, Bhubaneswar Sharma, my lord, the bottom.
This is enclosed by whom? By the
By the
petitioner?
petitioner, my lord.
Then?
Now, lordship kindly turn to my lord. ACR for period 2015 to 16.
15-16, okay.
Lordship, in the bottom, my lord.
Oh.
His period was, my lord, calculated here, my lord, from 01 to 04 2015 to 31/3/2016. Then, my lord, 1/4/2016 to 4/7/2016.
14-7.
14/7, my lord. Then there is no ACR, my lord. From, my lord, 2016 to 2017, there is no ACR. And it was calculated, my lord, from 2010 2017. Next, my lord. To 14/1/2019. Then more than 1 year, my lord, here. And there is no remark here, my lord. So, my lord, there is a gap, my lord, from the period 15/7/2016 to 19/10/2017. There is a clear gap for 15 months.
19-10.
19/10. 19/10/2017.
Yes. Government has not raised any objection on this.
No, I think, my lord, they have not checked up, my lord.
Yes. Then?
And so, my lord, the plea of the writ petitioner, my lord, regarding continuation of 5 years ACR, my lord, is not completed here, my lord. Calculation of 5 years, my lord, is incomplete.
So it starts from 1-4.
Lordship.
1-4 to 11-4. 11-11, 2014.
Lordship.
Then 12 to 15. 15 to 16. 16 to 17. Okay.
And in my affidavit, my lord, I have also applied for RTI, my lord. Is 75, my lord. Here also there is a gap. Bhubaneswar Sharma, serial number 2, my lord. Here, my lord, 1/4/2014 to 4/11/2014. serial number 2, my lord.
The-
Then, my lord, 14/7/2016 to 31/3/2017. So, my lord, there is a gap, my lord, from 5/11/2014 to 13/7/2016.
Hmm.
Regarding ACR, my lord, so 5 years continuous ACR is not available in respect of the petitioner. And second, first point I have raised, my lord, that writ petition is not maintainable because there is a specific, my lord, remedy under the statute.
Yes.
But when there is a specific remedy under the statute, my lord, writ petition is not maintainable. He has not filed any appeal. And in this regard, my lord, I want to place one judgment, my lord, 2014, 1 SCC 630, my lord.
What is the name of the party?
Commissioner of Income Tax and others, my lord, I am furnishing copy.
Kapil Das.
Lordship. Here, various judgment has been discussed by the Supreme Court, my lord.
Yes.
In this case also, my lord, the writ petition was filed without availing the appeal. And
This is a revenue matter.
even the principle, my lord. Principle is, my lord,
All right.
lordship.
Okay. Yes.
And regarding, my lord, constitution of committee, my lord. He has participated in the committee, he faced the interview. Now he cannot, my lord, say that the committee is bad. So on this 3 point, my lord, writ petition is liable to be dismissed, my lord. And the authority, my lord, after assessing my ACR and service particulars, my lord, found me suitable and promoted me, my lord. And I have been working, my lord, since the date of joining.
All right.
I have a short reply on this point. Regarding ACR, what has been projected? Para 16 and 17 of the petition.
Of?
Writ petition, page 7. They have sought the RTA information received by me, which has been annexed with the writ petition. Para 16, Lordship.
Yes.
Petitioner has also collected the statement of ACR for last 5 years of other service particular to the candidate applied to the post of revenue solicitor. Statement of ACR forwarded by the Deputy Commissioner of the Selection Committee. As per said statement, ACR of Umesh Chandra Das has been reflected as follows. Specifically from 1/4/2014 to 31/3, thereafter 1/4/2002 to 3/12/15. Good, very good. Totally serious numbers. Next one, let's see for the case of the petitioner. ACR from 1/4/2014 to 31/17/19 are received as very good. No DP pending. Separate
No,
statement.
he points out that in para 16, you see between serial number 5 and 6.
No, Lordship, this is para 16 is the regarding his ACR.
His ACR.
His ACR specifically with the period, Lordship. And regarding my ACR, para 17, Lordship. I have given the specific 1/4/2014 to 11/11/14. Thereafter 12/11/14 to 31/3/15. Thereafter, Lordship, 1/4/15 to 31/3/16. 1/4/16 to 14/7/16. Thereafter 14/7/16 to 31/3/17. Thereafter, Lordship, 20/10/2017 to 14/1/19. Thereafter 17/1/19 to 31/7/2019.
Where is the ACR here? Let us see from the records.
Record very good. And what has been replied?
Page 383 and 384.
380.
Here is annexed in the petition also.
Huh?
Here is annexed in the petition also.
But since the records are here, let us have a look.
383 and 384.
Intentionally, that has not been shown earlier. Because ACR, my submission was very
We
good.
have got the record.
384. 384.
383 and 384.
383. Now 383 is what is reflected, is also part of the petition. There it says 1/4/2016 to 31/3/2017. Then next slot is 2011/2017.
That is the RTI information I have received.
Huh?
That information has been received through RTI.
No, RTI is all right, but your ACR should also reflect it. You verify and tell us from the record.
And Lordship, what has been replied to the para 16 and 17 by the Deputy Commissioner? Kindly see the Deputy Commissioner's reply.
Just 1 minute. Mr. Fukan, you come to page number 7 of the writ petition.
Number 7.
Yes, para 17. Uh, 31/14/7/2016 to 31/3/2017. Then next lot is 2010.
17.
Now what has happened in between?
15 months.
Check it up there.
You check up, tell us what happened. And where is the this selection committee? There'll be an agenda.
Yes, sir. It's in
You pointed out.
675 and 676.
There is some-
Value to the meeting and the agenda.
No, page number, page number, page number. $600. What is the page number?
676 and
676.
675. 675 and 676. Minus of the meeting and the
$675.
and Lordship, as per the rules, ACR grading
ACR.
This is the my notes. My notes we have. What is the agenda to the my notes? To the meeting.
just a second.
The meeting is held for a particular purpose, which is made out from the agenda, which reflects why the meeting is being held. Yes.
And Lordship, para 16 and 17 we have made a categorical statement, and thereafter the reply has been given by the Deputy Commissioner regarding para 16 and 17. Lordship will find affidavit of the Deputy Commissioner at page 34.
Page?
Page 34. is the Deputy Commissioner's affidavit to record the ACR. It was shown by Dr. Priyanka Kashyap. Page 34.
Yes, page number.
Page number, Lordship will find 35. Here, Lordship, this 16 and 17 has not been replied at all by the Deputy Commissioner. Secondly, Lordship will find the affidavit of the Lower Assam Commissioner. Here, Lordship, page 47. No comments. Para 47, para 3. No comments.
Okay.
And Lordship, the affidavit of GAD at page 40, the 11th question, para 15. He admits the contents of the petition.
No, the question is
Regarding gap period.
you as an employee, where
I
were
cannot
you?
write to ACR, Lordship.
Huh?
I cannot write by ACR. ACR will be written by the Deputy Commissioner.
No, but where were you posted at that time?
Deputy Commissioner already.
There was no ACR.
Because Deputy Commissioner is the authority of writing ACR.
All right.
Secondly, Secondly, Lordship, the earlier petition also filed regarding selection to the post of administrative officer by the petition, by another petitioner, regarding selection to the post of administrative officer by the Deputy Commissioner in Albany. This is revenue solicitor. One advertisement was issued for selection to the post of administrative officer. That petition also allowed by the Honorable Court filing petition without availing the petition.
Where is that order?
I will give the order. Yes.
No, that is what your
Regarding Lordship filing appeal before the
alternative remedy. Yes, yes, alternative remedy. Yes. That's all.
And regarding Lordship one period, what they have projected, Lordship, the 15 years of service, long service, minimum qualification is 15 years of service, and revenue branch in special. What has been projected that he worked more than revenue branch is not totally correct. I have made a categorical statement that he has not worked in the revenue branch. And I can also file a short affidavit to that effect. How many days he worked in the revenue?
After the hearing is over.
It is not necessary at all. But Romani Malla Court's case, I will give a copy.
Please, please, please.
This is administrative officer. That is administrative officer. Regarding appeal, you have said that regarding appeal, there is a provision for appeal. That is why it should not be entered. Same provision, appeal is provision, administrative officer. This is allowed by this court.
Please go ahead.
And he is the sending officer.
So the facts and circumstances in that case is totally different.
Please,
What he's referring to, I was in the other case also. In that case, the
Provision of appeal is same as you have argued.
We are keeping it for 14th. We'll try to dictate the order in court on 14th. And whatever you want to submit, you submit by today. And you point out the records.
pointed out, I'll give a note. And regarding the agenda is not the minute soon is. They have directly.
There must be an agenda.
And I'll get
You get your instruction.
Appellate.
List, maybe matter be listed for 14th for further hearing.
Well, produce the records on 14th again. Today I will not have
But on 14th, we don't want to be told that the records are on the way, not available, council not available. We are passing orders.
only agenda thing and rest everything.
Whatever you want to point out, you point out.
Regarding assessment of merit,
And Lordship, just
how
one-
merit has been assessed?
One thing.
Because merit is the only criteria.
One thing according to the rules, 15 years in general. Apart from that, ACR gradings, along with that, the service particulars. Three of them together are taken into consideration, then an appointment is.
No,
So
taken
only
into
nothing-
consideration must be reflected somewhere.
But in the advertisement itself, my lord,
And Lordship, it's given
at
here.
least 15 years.
It's 8-1.
15 years
It is all
not,
right, but somebody who's got 15 years, who has not got 15 years, who has put in that money, some assessment evaluation has to be done.
15 years, my lord, in the deputy commissioner establishment.
Mr.
In a
Ali,
lordship.
we are not disputing that.
Lord. That,
Is it for
that-
the court to make an
No.
assessment that
No.
say which
That
person?
one should, my lord, perform such and such period in revenue, such and such department. There is no such
That is
specific
what we want
requirement.
to find out.
15 years, my lord, in the establishment and
It's
revenue.
clear, Since AO and RS is the same thing, but of course the job profile is different. 15 years is required, along with that, your lordship, service particulars and this thing, it's in 8-1 is given. Having served at least 15 years in any deputy commissioner's establishment, having work experience of different branches in general and the establishment of branch in particular. And it is more specifically explained in 8-3. There it is specific, your lordship, apart from 15 years, appointing authority shall obtain annual confidential reports of the last 5
You have,
consecutive years.
none of you have relied upon any case law to show what is the extent and how judgment, how the decision is to be taken by the department, how the inter se evaluation of merit is to be taken.
I have given a circular issued by the GA department. It has.
That is not on record.
Record also. That circular is on record. What's it? And listen to the circular.
No.
That is a GAD circular.
Page number?
That's it. Page 22, Lordship. Strictly on merit.
How is to be merit assessed?
On the basis of ACR, personal department notification.
Not only ACR lordship, service particulars also, experience.
Yes, yes.
Both. He's only
All right.
taken one. I've got the
List on 14th November. for further-
Assessment of annual competent report of every eligible candidate
and service particulars.
All right. we'll hear. 14th.
and relevant service particulars.
Yes. Yes, Mr. Bhatti.
My lord, by this petition, I have challenged the order dated 17/6/2019 issued by the commandant dismissing the petition from the service from 7/6/2019. In this particular case, my lord, I was appointed to the post of the constable general duty on 22/7/2006 and on 10/1/2019, I obtained the leave from 10/1/2019 to 9/2/2000.
Where is the inquiry report? Inquiry?
Inquiry, my lord, that report they did not supply to me, my lord.
Huh? Not supplied?
Yes.
Was the inquiry not supplied?
Lordship,
Yes.
he was declared deserted.
Deserter.
Yes, Lordship. He had never turned.
Then he has to be arrested, brought in.
Yes, Lordship. We had already,
All right. Anyway, where is the inquiry report? Available in the records?
Lordship.
My lord, they have.
In Hindi or English?
It is in English. Most probably it will be in English. And if it is in Hindi, in that case, I will translate.
We'll just rise for 2 minutes.
74 and a rule said there is a provision that he could be declared as deserter. And before declaring him deserter, we have given him ample opportunity. We have even asked him.
Inquiry report.
Lordship.
He has preferred an appeal. How have you preferred an appeal?
Yes,
You have preferred an appeal
yes,
without looking into the inquiry report.
yes. Because it was not supplied to me, my lord.
See, what is the point in the appeal? If the copy has not been furnished, you'll have to furnish a copy.
Lordship, I prefer a little lordship. Lordship, before that, lordship, because facts are not exactly what is his spelling. On the last occasion, he is relying on Parmar case, lordship. But Parmar case is a totally different footing, lordship. Here, in that case, the person, petitioner was transferred. Then he could not join, and that is why his leave was not willful, lordship. But here, after getting every opportunity, he never appeared, nor returned back, nor reported, lordship.
All right, but then what about non-furnishing of a certified copy? How will he know what the inquiry report,
Lordship,
whether it was sent?
no, lordship, it was sent, even it was published, paper publication was there. We
What
have sent
inquiry
it.
report?
No. Asking him to join, asking him to come. Only after he reported, lordship, he will be supplied, lordship.
No, that cannot be, no? If he has preferred an appeal, then the appellate authority should have made an attempt to supply in the copy.
Lordship, that is not in his appeal, lordship.
The appeal was cited in my absence.
Where is your appeal? Where is your appeal memo?
My lord, my appeal memo, your lordship will see. The order is at page 39, my, and my appeal memo is at page 28, my. 28.
36 is the translated copy.
36 is the translated copy.
36.
Yeah. Note 36, my lord, it is noted.
This is what, an appeal? 36 is the appeal.
28, my lord. Appeal is at page 28.
But you did not mention anything about non-service of inquiry report, non-supply of inquiry report.
Yes, my lord. It is not mentioned, my lord, because he is a layman, my.
So you have to make out a case that ECIL is not applicable.
Yes, Lord.
ECIL is not applicable here.
Lordship.
Why?
Yep.
Where is the order? Is there any order declaring you deserter?
Yes, sir. That order I have annexed, my lord.
Page number?
That it has been referred.
Huh?
It has been referred in notes I annexed, but it has been referred in the imperial order at page 26, my lord. Page 26.
Hmm. 26.
Yes.
Hmm.
The last but first paragraph. And whereas when neither you or surrender yourself before the police authority or the unit or you were apprehended by the concerned police, you were declared as detained by those such as provisions contain a copy of the order declaring you as in full. But actually it was also not supplied to me. This copy was also not supplied to me. Though it has been written so far this order is concerned, that it was annexed with this order, but it was also not supplied.
No, no, which order?
This
Page 26.
Deserter.
Where did you get it?
No, I did not get it. 1519, madam. Dated 1519. It was given to the police, madam, not to me. And the copy of it was also not supplied. So it has been mentioned in the impugn order that it has been supplied to me.
Yes.
Relevant page 83, that is continuation of my affidavit, Lordship, annexure G, Lordship. There, that is the order 1990. Oh, that asking that declaring him deserter, Lordship. Order for declaring so and so as deserter. Page 83. Prior to that, apprehension roll was also issued, Lordship. But neither he could be found, Lordship, neither he nor he reported back. Last para, Lordship. Now, neither you have surrendered yourself either before the police authority of the unit nor the concerned police has apprehended you, and hence as per provision
You are
contained
reading from page?
last page 83.
83.
26, page 26 of my affidavit.
26.
Yes. Running page 83.
No, running page is 88. Here.
Now, last para.
Deserter.
Yes. Now, neither you have surrendered yourself either before the police authority or the unit nor the concerned police has apprehended you, and hence as per provision contained under section 74(2) of SSB Act 2007, I the undersigned hereby declare you as deserter with immediate effect. Then, Lordship, the show cause notice, and where we have, after giving declaring him deserter, we have issued this on 8/5/19. Next page. Now the notice, last para. Now the notice is being served upon you with the decision to assume your duties within a period of 15 days after receiving this notice at so and so, failing which you shall be dismissed from service. The second so cause notice we have also issued. Next page. Then we have also given it in paper for paper publication, Lordship. Subsequently, the order for dismissal, Lordship. Which he had challenged the dismissal order. He had filed this appeal, Lordship, annexure L, and after consideration by the appellate authority, found no reasonable ground for considering his appeal, Lordship. Page 35 of my affidavit. That appellate authority had considered everything, Lordship.
How can appellate without giving him a copy of the inquiry report? He doesn't know what is there in the inquiry report. Even the appellate authority would have furnished an inquiry report to him.
But he had never applied for those things. He
May not have, but it is,
Lordship, but
no,
he
but
filed an
it
appeal.
is
Lordship.
incumbent on the, unless you say that ECIL is, the law laid down by the apex court is not applicable to these proceedings. Unless you distinguish. There are
Lordship,
so many judgments after that. You conducted an inquiry, he's filed an appeal, he doesn't have a copy of the inquiry report. What kind of appeal has the appellate authority decided?
Then Lordship may kindly fix it after a week, Lordship. I will go through it.
You
Lordship.
get these instructions, you tell
Lordship.
us. And meanwhile, if it is possible, get some translations of these depositions. It will be relevant to go through the. You request your department, they will furnish. We can do it through the registry, but it will take some time.
No.
If you can do it in the meantime, we can dispose of the matter. Not having supplied an inquiry report in today's context will be difficult for you to overcome, being candid about it, in view of the judgments of the apex court. Now, unless you say that, no, this, on the facts of the case, it doesn't call for it, or he is not prejudiced. He is not prejudiced by not being furnished a copy because of these reasons. You look into it, come back again. When can you get it?
2 weeks, Lord.
2 weeks. Only. 23rd, no, not 23rd. 30. You can have it on 30 November. 13 November.
In the meantime, my lord, email it has a copy of inquiry report.
Lord,
No, that she will furnish. We can't direct her to give you. If she is magnanimous to serve you a copy, it's a different issue. But list again on 30, enabling the respondent counsel to furnish the relevant records along with translation. And attempt will be made to dispose of the petition on the said date. 30.
My lord, inquiry report may also be directed. A copy of that.
We can't direct. It is there in the record. If you want to see, you see. As on date, we have not taken a decision that we'll have to direct them to furnish you a copy. Rest, of course, if she's willing to show it to you over a cup of tea, we cannot stop it.
Offline.
Yes.
I pay for a seniority of Hada 50 best, and Lordship specifically ask them to obtain certain
Made Mr. Lordship. So although we have filed our affidavit, there was a query that Lordship on a subsequent date when list was been prepared, and his name has been considered in the 58th batch, Lordship. Accordingly, Lordship, we are required to provide specific instruction, Lordship, that why could not on 49th batch, why it is only 58th batch, because his junior colleagues were in 47 or 48. Accordingly, Lordship, it is true, Lordship, we have written several letters. Today, Lordship, again one letter we have received from the concerned party, Lordship.
What does it say?
Matter is being examined and they require 10 days more time, Lordship.
All right. It is submitted by Mr. Sorma Puralan, Governor Advocate, that further 10 days time has been requested for by the department to examine the issue and furnish necessary instructions. As to the query raised by the court, as to the query as to whether the petitioner, why the petitioner was not accommodated in the 49th batch of SI within bracket Anam branch of Assam Police instead of the 50th branch. 50th batch of SI Anam branch. Stop. Matter be listed after 10 days. Mr. You are led by counsel. Like Mr. PP Dotto appears for the petitioner. List after 10 days.
Maybe. Matter regarding medical reimbursement.
Yes.
Lordship, in this matter, I have received my instructions, Your Lordship. Placed it. I've got my instructions, Your Lordship. Here, my lord, the director has written to the Secretary Government Elementary Education. The concerned petitioner has failed to submit the referral medical board certificate and administrative report, as he was referred by the assistant professor of physiology, Silchar Medical College, instead of the standing medical board, Silchar Medical College, Silchar. That is required, Your Lordship. So only after that, Your Lordship, the things will get processed.
No, what is the meaning of this? What do you want? What do you want to say?
So I want to say that, Your Lordship, he has to submit the petitioner has to submit to the DIS the referral medical board certificate and administrative report.
It is not here.
It is not here. So that he has to submit that to the DIS. They will submit it to the thing. It's on the petitioner has submitted. He has submitted the assistant professor of physiology's thing, Lordship, instead of the standing medical board. So he has failed to give the referral medical board certificate. And
Where are the rules? Where are the rules?
The medical board will know.
Where are the rules? On what basis you are saying this is necessary?
Lordship, I'm on the. Lordship, I'll file an affidavit. Lordship.
You have not filed affidavit.
Lordship, question is that Lordship, in our High Court judgment, Lordship, page 48.
Lily Mazumdar.
Lordship, in also finding a Supreme Court, that is Shiva Khan Puja and Union of India, Lordship. The claim cannot be denied on technical ground. Any technical ground, the claim cannot be denied.
What is the technical ground?
Technical ground, it is trying not to go to the medical board. How can I know it is medical board? Medical board is not a continuous Lordship. In a case, it may be conducted or held. How can I know?
Regarding the rules,
so it is very difficult. That's why our Supreme Court have denied this point. So there are a number of.
Have you gone through the judgment, Mr. Fukan?
Page 47. Lily Majumdar.
Yes, sir.
Do you dispute the genuineness of the claim?
Lordship?
Do you dispute his claim?
Lordship, as per, we don't dispute anything, Lordship, but the process, Lordship, since this has been given, that the referral thing.
So that is why I'm asking you, have you gone through the judgment? Come to para 13, the judgment.
Okay. The Health and Family Welfare Department will be able to answer that.
You are appearing for whom?
I am for elementary.
Under whom? Under which department he is employed?
He is otherwise employed with the elementary.
Who is supposed to reimburse is the medical, the health department.
Their approval.
Submit the medical admissibility report.
Admissibility. That's
Otherwise, the parent department will have to.
But the admissibility report only has not been given.
By whom?
We have to receive all the
document. So that has to be given, yes, he has to submit that. He has to submit that to the health and family welfare. Then that will come to the director, and then accordingly, my lord, will be showing.
You're not clear what you want to do. What is this? What is this? Kindly read it again. Read it. Read your instruction.
In response to the above mentioned, this office letter, DIS Hailakandi submitted the proposal by this letter under reference number so and so. By stating that the teacher concerned failed to submit the referral medical board certificate and admissibility report, which he's talking about, as he was referred by the assistant professor of physiology, Silchar Medical College, instead of the standing medical board of the Silchar Medical College, Silchar Medical College Hospital. In this regard, the DHS Hailakandi also requested the DIS Hailakandi to submit the proposal along with the referral of the standing medical board SMCH. From their end, why this letter? As per procedure, referral of standing medical board SMCH, Silchar and admissibility report are required to accord sanction. So actually, if this particular thing is submitted by him to the field officer, I think it can be done immediately to accord sanction.
It is also denied by High Court. Our High Court also our Supreme Court also. It is not the point. It is not the fact. So it is.
Lordship may do one thing. Lordship.
Very serious patient. Lordship, without money, he can die. So he is an employee of Assam government.
He has submitted some document. Yes, it is said that teacher concerned has failed to submit.
Also, reimbursement certificate
And
is also there.
instead of the standing, he failed to submit, as he was referred by assistant professor physiology SMC.
Yes, sir.
Now this he has submitted before whom? Before whom? Before the education department.
Yes, sir. Yes.
Then you have not forwarded it.
But this thing, no, Lordship, we require the
It is
referral
for
of
the health department to decide whether this is relevant or not relevant. Why have you sat on it?
Lordship may kindly fix this matter after 2 weeks. Lordship, I'll get specific
Not
instruction.
2 weeks. This man is asking, he's dying, he's asking for money. And you are trying to decide who is to be, to whom the responsibility is to be shifted. Notwithstanding a judgment of this court.
No, Lordship, what documents is supposed to be provided by the petitioner, Lordship, I'll get instruction, and what is the status of this. Otherwise,
Friday, we'll take it up on Friday. Do it.
Lordship, can it be on Wednesday, Lordship? Coming Wednesday.
50% maybe.
On Wednesday, Lordship.
50% petition.
No, Friday. Get it on Friday. You just have to clear it. There is a judgment of this court. Has any appeal been filed? No appeal has been filed.
Lordship, in that case, can it be on Tuesday, Lordship? Friday, I have some. Tuesday or Wednesday, Lordship? Any day, Lordship.
No,
Friday. Let us have it on Friday. You are not there. You ask your colleague to be present on Friday. Get the instructions. Learned Counsel for the Health and Family Welfare Department, Mr. D. Upamanyu, is permitted to obtain the relevant instructions. D. Upamanyu, along with Mr. A. Fukan, Standing Counsel Education Department, are permitted to obtain the required instructions with regard to the bills, medical bills, claim on the medical bills raised by the petitioner, and the status of the process required to be undertaken by the respective departments. Stop. The learned counsels will also apprise the court in respect of the action taken by the department in view of the judgment and order rendered by this court in 5/3/2021 passed in WPC 4492 of 2018. List on Friday. Mr. Alamgir appears for the petition. Yes, Friday, get your instruction. Yes.
Well, in this case, what is happened actually, my lord, petitioner, a private respondent has been, my lord, incorporated in the list of, my lord, selection list, my lord, for compassionate ground, appointment on compassionate ground, my lord.
after the death of our father, my lord. And my lord, my lord, who took my lord signature, my lord, fraudulently of my mother. I am my lord petitioner here before this honorable court. Is the son of the first wife of the deceased person, my lord, who was a my lord, railway constable, my lord, and died in encounter in the year 1998. Recently, there is a move, my lord, by the government, and this private person, private petitioner has been, my lord, already, my lord, incorporated in the list, my lord. And his position is, my lord, 207, my lord, in the list, my lord. Next, sir, my lord, 7, and page 40, my lord. Subsequently, inquiry was also held, my lord, and government already filed affidavit, my lord.
Yes, what is the affidavit in the
Yes, my lord, in the government.
Then basically, Lordship, it has come to light, his cousin brother has done some Lordship illegal thing regard to Lordship.
Yes.
Saiful Islam, son of so and so, submitted complaint petition on the same subject matter, alleging that Asifur Rahman, his brother, had illegally taken signature of his mother. On pair number 5, Lordship, Asifur Rahman, his father, had submitted complaint petition against Safiul Aslam, where the petition alleged that Safiul Aslam has taken his signature on a blank stamp paper and made NOC and submitted the same at Assam Police without obtaining his consent. That with regard to the statement made in paragraph 5, the answering department states that the office of the department only causes an inquiry into the allegations leveled by the petitioner and asserting the genuineness of the documents submitted by them. After the inquiry report was submitted by AIGP. The inquiry officer has not recommended anyone's names for the post in the inquiry report.
Where is the inquiry report?
This is on the inquiry report, Lordship.
Huh?
Lordship wishes to see it is not in the Lordship affidavit, Lordship. We have got subsequently.
What is there in the inquiry?
In the yes, Lordship. In the last paragraph, what I have found, Lordship, in the finding, late Abu Bakr Siddiq.
No, this first tell us what is this inquiry about?
Inquiry in the Lordship, what it has come out, Lordship?
Oh, who has initiated the inquiry for what purpose?
Inquiry in regard to Lordship, allegation was that Lordship, his brother, by misleading some documents.
With regard to the allegation raised by his brother, that is the inquiry.
Yes.
Is that the inquiry?
Yes, that is the inquiry.
All right. So what is the finding there?
Finding, Lordship, his brother has given one NOC. That
no, he has given an NOC.
No, this Asifur Rahman, Lordship. Asifur Rahman submitted the prayer for appointment along with NOC from Moksed Ali and Sajid accordingly.
Who is the brother?
Asifur Rahman is, Lordship, his second mother's son.
Whatever it is, his brother.
His brother. Submitted the prayer for appointment.
He submitted a complaint.
Lordship.
Asifur submitted a complaint that he had forcefully taken a signature on a blank paper, NOC, etc. That is a complaint. You are not even prepared, Mr. Counsel. At 2, go through your records and address the court. At 2. Don't prepare your briefs in court. You are supposed to prepare and address the court. If you are not ready, you take time, prepare the briefs.
In fact, Asifur Rahman, he is the Lordship.
Mr. Counsel, if you are not prepared, you take time and prepare and address the court.
What's up, something?
May please, your Lordship. May pay Lordship demand be taken on Thursday next.
Next Thursday?
No, next day. Day after tomorrow.
Day after tomorrow.
Day of Lordship.
What is the matter about?
Well, the petitioner challenged the recommendation of the private respondent for filling up a post in question, that is assistant registrar, through internal promotion and the appointment. Recommendation of the board and the appointment. That is the challenge. The pleadings are completed, my lord, and I was told on last occasion that the records are also ready with them. Records were called for by this court.
You want it on Thursday?
Thursday, Lordship.
All right.
Well, I am the private respondent. Thursday, my lord, a little problem. Whether my lord tomorrow or on Friday, my lord.
Even me, my lord, tomorrow or day after, my lord,
All
on
right,
Friday.
on Friday.
On Friday.
On Friday, Lordship.
On Friday.
On Friday. Or you come on Saturday.
As your Lordship pleases, or depending on convenience
There's
of
a
mine.
direction for disposal of the admission space.
Hmm?
There's a direction by this court, my lord, for disposal.
Yes, yes, we'll do it, Mr. The council.
Thursday,
the
my lord, I have got some
IIT.
other matter fixed, my lord.
No, that's all right. Then Friday, we can have it on Saturday. Saturday? 18th
18th, yes, 18th Saturday is
18th.
open.
is court working day.
My lord.
Yes.
18th.
Oblige.
Well, in that case, my lord, let us have it on Tuesday, man. Or tomorrow, man.
All right, Friday. Let us keep it on Friday.
Friday, Friday.
List on Friday. And the joint prayer of the councils for the parties. Mr. B.T. Goswami for the petitioner, Mr. R.P. Kakuti, senior counsel for IIT, assisted by Mr. A.B. Day, Mr. T.J. Monto, assisted by P. Sharma, M.S. P. Sharma for
Respondent number 7.
7, M.S. R. Devi for respondent 1.
Right.
Oblige.
Six to two. No, at 2, at 2. At 2. We'll take it up at 2 o'clock. Where is your counterpart?
Lordship. Already. 16.
Yes.
My senior is on legs of 4-6 manner. Maybe pass over for time being.
On the last occasion, his part was concluded. Only my rejoinder remained.
All right, we'll take it up at 2, second half.
Obliged.
Yes. एक काम करोगे council रुकिए से call दिया है. Yes, Mr. Senapati and Mr. Bora.
Your Lordship, we had a matter. Your Lordship has fixed it up on at 2 p.m. Can it be taken up on 23rd?
No, we'll take it up now.
Yes, Your Lordship.
That is why we called you.
May please, Your Lordship. But before starting the matter, is the matter related to challenge to a termination order without a departmental proceeding. Now the petitioner was appointed in 1982 as Khalasi. Thereafter, in 1994, he developed a nervous degenerative disease.
Sorry. Yes.
In 1992, the petitioner was appointed as Khalasi in NIPCO. In 1994, he developed a degenerative disease. After 31 years of service, in 2013, he took a leave for serious problems regarding his health, and he could not. He sought extension, several extensions, but when the authorities told him to rejoin, he could not join. Thereafter, he was about to retire on 31/5/2014, but a day before his retirement, he was removed from service. Now, Lordship, my case is that there was no notice regarding termination, and there has had to be a departmental proceeding, as overstay of leave is a misconduct, and I could only be removed through a departmental proceeding. But no such, Lordship, page 23 is the impugn order.
Yes.
Now the second question is,
take us to the impugned order first. Yes.
Notice for removal from service. Several letters were sent to you, and finally by press notification published on an Akomia Proceeding on 22/1/2014, you are asked once again to report for duties within 15 days from the date of publication on the newspaper. But you have neither resumed duty nor sent any communication and continue to remain absent unauthorized. Your above conduct and action confirms that you have voluntarily abandoned your service and are not interested at all to serve the corporation. Please note that the final notice published in the newspaper, you have been informed in clear terms that in case you fail to comply with the instruction to resume duties, your services will be terminated and your name will be struck off from the rolls of the corporation on the expiry of time schedule mentioned therein. Therefore, in the interest of works of the corporation, your services have been terminated and you are no more an employee of the corporation with effect from 14/1/2013 as decided by the competent authority. Now, Lordship, secondly, Lordship would see that this letter is issued on 30/5/2014. My date of superannuation is 31/5/2014. Whether this letter is issued, but it is whether I receive within my period of service or because ultimately this termination order will gain legal force whenever it is communicated to me. Lordship, I would also press upon that if it is served upon
but
me.
You did not join. In the opening lines of the letter of the order says several letters, press notification. Where were you?
Lordship, what has happened? Lordship, I was suffering from a severe nervous degenerative disease. Lordship, now also I am totally in bed. And second,
Where are your medical documents?
Lordship, medical documents, Lordship, yes. But I have to gather, Lordship, it started, it's a degenerative disease. Lordship, page 617, 16 is a type copy. Dinesh Chandra Sharma of Nepco, Lanka has been suffering from theoretic lumbar vertebra reduced vertebral spine spondylitis. Considering, I advise him to attend GNRC Guwahati for necessary investigations. That is one. Because it started in 1994, Lordship. Generally, the spine diseases are like this, Lordship. It grows.
No, I am not a medical professional. I do not have medical exposure. So I cannot come to a conclusion by reading these 2-3 lines that it is a degenerative disease and which prevented you from rendering your service.
Yes, because Lordship, I was transferred in while I was left with 1 year of service. I was transferred to Mizoram. Initially, I was posted in Lanka, Assam. When I was transferred in Mizoram, I worked for some days. I obtained leave for severe health condition as I am been instructed. Then I could not return. I was continuously seeking extension, and Lordship would see from the affidavit in opposition, all the letters of seeking extension are annexed to the affidavit in opposition.
Extension, indefinite extension can't be given. You are working, you have some responsibilities. Unless you support it by proper medical documents to show that the degenerative disease has prevented you from performing your duties, then what happens?
Lordship, ultimately, yes, Lordship, even Lordship, for a moment, Lordship, let me presume that I have abstained from doing my service and intentionally abstain from my service. At most, it is a misconduct, Lordship. Therefore, some proceeding has to be there, Lord, as per their rules also. If suppose I am overstayed a leave, I have overstayed a leave there, therefore it is a misconduct in service. Therefore, for a misconduct, there has to be some departmental proceeding, Lordship. And secondly, Lordship, if the termination order is...
Do you have any set of rules governing your service?
That is one thing, Lordship. There is a rules, NEPCO Disciplinary and Appeal Rules 1980, but the copy could not be traced out anywhere. But that is there because I have seen in various judgment it is referred. But the copy I could not gather. I could gather some disciplinary conduct rules from Central PS Public Sector Enterprises, which says that overstaying leave is a misconduct. It falls under the definition of misconduct. And there is a particular procedure. And that 1980 NEPCO appeal rules I could not gather. Lordship, this morning I have asked my senior friend. Yes. He has promised me to give.
Promised you today?
Yes.
Yes, Mr. Senapati?
Your Lordship may just see page 56 of my affidavit in opposition.
No, firstly, are you bound by your promise?
The promise?
Yes.
He requires it, then I will definitely give it. Your Lordship.
Page 56.
Of my affidavit in opposition.
Yes. Yes.
Clause 7.17, the bottom last clause, Your Lordship.
Yes.
If any employee unauthorizedly absent himself from duty for more than 10 consecutive days without any intimation, a notice shall be issued to him directing him to report for duty forthwith, and in any case not bound 8 days after the issue of the notice. If he does not resume duty within such period, the employee shall be deemed to have left the service of the corporation on his own accord, and his name shall be struck off from the rolls of the corporation with effect from the date of such absence automatically. Here, Your Lordship, the petitioner applied for a leave of 2 days. That was on 7/11/2013. 14 and 15, he applied for leave. Thereafter, he never came back. Subsequently, he sent us a medical report, which was unsigned. And if Your Lordship also sees, Your Lordship may just see the leave application first.
Where was the notice that you sent to him?
Those notices are, Your Lordship may just see.
Page?
I'm coming, Your Lordship. Page 47, it's a paper publication.
No, the rules talks about a notice.
Yes, Your Lordship. 7/1/2014. Then another at page 48, the same. And then.
No.
Prior thereto also.
These are publications.
Publication.
Notice
is also there. Your Lordship may see page 42.
42. Yes.
With reference to the above, when a report to so-and-so, you left station on 14/1/2013 by applying casual leave for 2 days, and thereafter you have not resumed your duties. Further, it has been recorded you have the habit of sending unsigned request letters without any date, seeking only extension of your leave by adducing the cause of absence as back pain. Your act of staying on absence has been viewed seriously by the competent authority. Accordingly, in connection, you are hereby asked to report within 15 days from the date of issue of this letter, failing which appropriate. Then 43 is another.
Was this served on him?
Yes, Your Lordship.
How do you say so?
That it has denied reply to her. Record. Reply paragraph 2, paragraph 13, affidavit in opposition.
Never received.
He said never received. Then I'll do some documentary evidence on this record. Then paper publication is the only option. If his reason is that he stays in a backward region.
Yes, the rules say so. The rules are very categorical.
Yes, Lordship would see just now. 17, my senior friend has pointed out 7.17. Lordship would kindly see 7.16. Serial number 1. There can be two.
Where is the page number?
56.
56, running page 79.
56.
Here is the 7.17 will apply to an employee which has left service without any intimation. But will not apply to an employee who has applied for leave initially and has never joined duty. For
the period you never joined, you had applied for leave for a particular number of days. You overstay that leave without any intimation. Will you not be covered under 7.7?
7.16, Lordship would see 1. If an employee does not join duty by the stipulated date, it would be open for the disciplinary authority to institute disciplinary proceedings against him. If during the course of disciplinary proceedings, he comes for rejoining duty, he should be allowed to do so without prejudice to the disciplinary action already initiated against him. And the disciplinary action concluded as quickly as possible. The question of regulation of period of overstay of leave should be left over for consideration till finalization of disciplinary proceedings. Lordship, against this is my contention that this will apply to me. The 17.17 will apply in a situation where an employee does not intimate anybody, just leaves the service. But I have applied for leave and overstayed the leave. Therefore, at least a disciplinary proceeding should have been there.
But you are not available. You did not come.
He never
How will they initiate a disciplinary proceeding?
Lordship, they could have initiated a disciplinary proceeding by proper show cause, Lordship. There is a rules, 1980 rules are there, Lordship. Rules are there if there is a misconduct.
Anyway, what would you have projected before the disciplinary proceeding? On the grounds of your overstay?
Lordship, obviously I have to cite the medical reasons only.
So these documents which are enclosing does not reflect it. It does not reflect that you require bed. You are required to be in bed, or there is no possibility of you going and joining.
Moreover, Lordship, as per my instruction, Lordship, his illness is very much severe, Lordship.
But it has to be pleaded case. If it is severe, then how would you have attended your duties?
Lordship, on 59 years, I have been transferred to Mizoram, outskirts. Lordship, in Assam, I could have done that, but in Mizoram, I cannot come because NIPCO projects are generally very
in outskirts area.
Transferred in 2011.
Whether I could have said this before or the authorities could have considered this aspect or not. If they give,
You,
they
you
have
furnish the report regarding whether the notices were served.
and
Find out.
and
Your
second,
Lordship, can I just point one thing? If Your Lordship just come to page 18 for a moment, writ petition. This is the medical.
Page 18.
Yes, Your Lordship.
18 is a part of the writ petition, part of paragraph 18.
Page number 18.
page number 18 is the typed copy of the medical certificate.
Okay. Sorry.
1A.
Yes.
Last line is allowed to do light duty. This is no doubt unsigned, but their own version. He is allowed to do light duty.
Not unsigned, but
Anyway,
19.
What is light duty?
That is.
Your employed is what?
Is Khalasi.
Khalasi. So Khalasi, what kind of heavy duty do they do?
But the terrains are very
We didn't say so.
And he joined in Mizoram in 2011. He disappeared from duty from 2013. 2 years he was there all along. 2013 he's been.
Where is your application on for leave?
Yes, it's in the affidavit in opposition.
Okay, we'll come back at 2. Come back at 2.
Much.
Yes.
In this case, my lord, the private respondent also, my lord, shown one affidavit, my lord. Here coming in this Guwahati High Court premises, my lord. I have annex here. The private respondent, my lord. He has, my lord, come here in the Guwahati High Court premises. Thereafter, my lord, NOC given. Sorry.
Yes. Yes.
Your Lordship, medical his leave application, Your Lordship has seen. The medical certificate Your Lordship has seen. Fact remains is that in spite of paper publication, in spite he have asked for extension, he never resumed back.
Fact remains that you issued a notice and terminated him. There has to be some process.
The process is as per 7.17 unauthorized. The only thing that my learned friend is referring to 7.16.
That unauthorized, there'll have to be a finding that it is unauthorized. Why it is unauthorized?
It is presumed that it's unauthorized.
Oh, you can't presume things like this. How can you presume? There has to be a finding that it is unauthorized.
That has been found.
In the order that you have issued, there is no finding that because of X, Y, Z reasons, this is to be accepted as unauthorized.
There's a finding, Your Lordship. Page 50. Page 50, affidavit in opposition.
Yes. So this finding in affidavit will not do.
But you have neither resumed duty nor signed and continued to remain unauthorizedly absent.
Page 15.
50. That's the termination order.
That order.
Right.
That order.
The first paragraph.
This is a notice.
30 May is the termination order. Prior thereto are the notices. First paragraph. Several letters were sent here and finally by President answer you have asked again to report for but you have
Is it a case of
unauthorized absence.
unauthorized? What is the meaning of unauthorized?
That you that without any application, without any leave being granted, you continue to remain unauthorizedly absent.
He submits that it is a case of overstay.
No.
Not overstay.
It's a overstay.
2 days he applied.
That will amount to overstay, that he has applied, been granted leave for 2 days or 10 days or whatever.
And
then he continues to be on leave. Is that the case? Or he simply disappears without any application?
No, it's not a case of simply disappearing.
Then it's a case of overstay. He has applied for leave. The leave was granted. He availed the leave. Then he did not join. He continued to be on leave. That is the case.
I applied for 3 extensions also.
Those extensions were rejected because those were unsigned.
Yes. You want to support your submissions by any judgments?
But the next issue is that the 30/5/2014, the removal order is there. On 31/5/2014, it's my last day of service. Therefore, on the date of my retirement, my termination order was not served upon me. Therefore, I remained on service on my day of retirement. Because Lordship, it's a legal principle that until it is communicated, does not become effective. So my detachment from...
Where have you pleaded that?
Yes, yes. Lordship, yes. One paragraph I have pleaded.
One sentence, one line is enough.
Yes, 9, para number 9.
Para 9, yes.
The petitioner did not know about the termination order as he was severely ill and came to know about the termination order only in the year 2016.
How?
Lordship, somebody from my office has told me.
Oh. That is not a very concrete statement.
Yeah. In the present petition, the petitioner challenges the termination order dated 30/5/2014.
Yes,
Therefore,
Mr. Senapati.
Therefore, my detachment from service is by way of superannuation and not by termination.
You have issued communications, but whether it was served?
That I'll have to check back and check. He has denied those, Your Lordship. I'll need that instruction.
Merely issuance of notice, you'll have to show that it was served at the proper address, postal receipt or whatever you want to reflect.
Yeah, Your Lordship, it's a 10 years back matter.
Whatever it may be.
Your Lordship may grant me some time to trace out the records. Your Lordship, I have to take instruction on that.
You have to make up your mind before you start arguing a matter. Once in the middle of the arguments, you want to take time.
Yeah, actually.
Then we had opened the matter for hearing. When can you get it?
Your Lordship, I just had a talk with my law officer. He says that at least give us some 6 weeks time because it's
No. No.
Then Your Lordship, at least 4 weeks, Your Lordship.
No, 4 weeks. We will give you 1 week time. It's a question of termination. Man has been terminated in
2014.
which year? 2014.
He
Then?
came to High Court in 2016.
Whatever.
That, 18.
But should it be a reason to grant you 6 weeks, 4 weeks time to trace out the records?
We'll try, Your
Trace out.
Lordship. Either it's there, not there.
Get back, tell us. You will take it up on
22nd, Your Lordship.
Yes, 22nd November.
Deeply obliged.
On which date the learned counsel for the NEPCO, Mr. Senapati, will apprise the court with regard to the records available in the office of the NEPCO as regards the service of the termination order on the petition. I.e., whether the termination order was served on the petition. Stop. List again on 22nd. Mr. P. Bora. Mr. Bora for BP Bora for petitioner, Mr. Senapati for NEPCO. Yes.
Deeply attached.
May it please, Your Lordship.
Yes.
My lord, I am appearing in item number 4. And the matter pertains to, my lord, the petitioner is agreed by the grading in ACR pertaining to the period, my lord, 2010 and 2011. In the humble submission of the petitioner, the gradings given by the accepting authority has been given, though he was not authorized to be an accepting authority. And my lord, he has graded me, downgraded me, in fact, my lord, as a reviewing officer, as an accepting authority, and as a first appellate authority, he has accepted. That cannot be done. Which will kindly, at a relevant point of time, the petitioner was working as a second in command in the CRPF, my lord, and his next promotional post was, my lord, commandant. Which will kindly come to my ACR. Here it is called Annual Appraisal Report. Lordship will kindly come to page 47 of the writ petition, 47. Part of my APAR. Major Lordship, Lordship. 47, man. Yes. Lordship will see grading by reporting officer. Very good. In the table, my lord. Grading by reporting officer. Very good. Grading by reviewing officer. Good. Under the column good, it has been signed. And kindly see the down below, my lord, signature and designation. MP Nathaniel, Inspector General of Office. Now, Lordship will kindly turn to the next page, at page 48. Next page, my lord, page 48. The same officer, MP Nathaniel, Inspector General of Police Operations, grades me as good as the accepting authority. So, reporting authority grades me very good, reviewing authority downgrades me as good, and accepting authority also accepted as grading as good. Now, Lordship, kindly come to the date, my lord. At page 48, it is 1/8/2011. And Lordship will now kindly come to the pre-page, that is the grading by the reviewing authority. It is 2/8/2011. So Mr. Nathaniel, as an accepting authority on 1/8/2011, he grades me as good. Then on second, my lord, he reviews it as a reviewing authority, which is not permissible, my lord. First, it is the reviewing authority, then it has to be by the accepting authority.
Could be an oversight.
But that is not the stand taken in the affidavit of opposition, my lord. They have kept mum about this in the counter affidavit.
Yes. Now,
my lord, Lordship will.
what are you arguing? What are your submissions?
My submission is that, my lord, these gradings are faulty, apparently. And as per the standing order, it is the IGP administration who should be the, I have annexed that standing order, my lord, who should be the accepting authority. And my lord, since the gradings are faulty, my humble prayer before this honorable court is that the matter should be remanded back to the authority, reassess the performance for this period, and a review DPC has to be held.
But these officers are not there.
But record should be there, my lord.
Maybe. But that particular officer under whom you serve,
Yes, I retired.
then
But my lord, if I have been wrong, I have to have some remedy, my lord.
you have to show us what is the course for remedy. Tell us. Remanding it back, if it is supposing on the basis of, let us say, is very good which you have got,
Yes.
is supported by certain other collateral cogent evidence.
Yes.
Let us say there is a reference to your self-appraisal report of what you have done or
Right.
what responsibilities you have taken, and
Right.
these are correlated with the grading given by the reporting officer.
True, ma'am.
In that case, without there being any change, you can perhaps urge that it could not have been downgraded. Right. So now the only thing is that this was not brought to your notice, downgrading. You
Yes,
are not.
my lord, it was subsequently brought to your notice. I have represented against it.
Okay.
I have filed an appeal. Appeal also rejected by the same IGP officer, my lord.
Hmm.
So one officer in the rank of IGP operation acts as a reviewing authority, acts as an accepting authority, and acts as
Now,
a
in his absence, who would have been the reviewing or accepting authority?
No, as per
Supposing he is the reviewing officer.
yes, Lordship will kindly come to page 54. 54. It is the standing order there. It starts at page 51, standing order number 56 of 2001.
54.
Page 54.
Yes.
Serial number 6, initiation and maintenance of ACR.
Hmm.
The procedure for initiation and maintenance of ACRs as officers as outlined, 6.1.1, 2 ICM, second in command. The ACRs will be initiated in duplicate by the commandant, principal, ADIG being the controlling officers of the respective unit, a sub-discipline institution as the case may be. The admin ACR will be sent to range DIG and the operational ACR to operational DIG. The range of operation DIG, after endorsing their remarks, will forward both the copies to the admin IGP. The operation IGP at the end of the year may, if need be, forward his appreciation, impression, any worthwhile achievement, misconduct, or slackness, etc., in the performance of any officer in writing to the admin IGP, who in turn would take these into account while endorsing the ACRs as accepting authority. So their standing order clearly says it is the admin IGP who has to be the accepting authority.
Hmm.
So there is procedural violation also, my lord. He was not authorized to act as an accepting authority.
Which paragraph again?
My lord, page 54, the bottom line. Admin IGP, who in turn would take this into account while endorsing the ACRs as accepting authority.
Hmm. Who is the person who was the accepting authority?
The IGP of administration ought to have been my lord, but the IGP operation acted as accepting authority and reviewing.
Is he holding dual ports?
My lord, to the best of my knowledge, no, my lord, because his seal is there, my lord. If he was holding his seal, ought to have reflected so.
What was your post?
I was second in command at the relevant point of time. Now, subsequently, in the year 2016, I've been promoted as commandant, and I'm at present posted at Chennai, my lord. And
What is this particular ACR? Is it admin or operational?
Operation, my lord.
This is operational ACR.
Yes, my lord, I'll also kindly come to page 38 is a self-assessment report, my lord.
Yes.
Page 39, the third para. During the said reporting period from so and so, the undersigned remained posted in the office of IGP of CRPF and held the charges of second in command intelligence. Page 39, third para, first three lines.
Is there a separate set of ACR's gradings for administration also?
As per the standing order, perhaps, madam, rule.
No, as far as you are concerned, only one.
And the IGP office ought to have submitted any recommendation or anything, my lord, to the admin IGP.
Yes, okay. Then what about any appeals?
Yes, my
Oh,
lord.
you have filed an appeal.
Yes, that was rejected by the same officer on the same line. IGP.
Thereafter, you have come before this court.
Thereafter, again, I filed an appeal to the higher authority, but it was rejected. Both the appeals were rejected, then I came before the court.
Okay. Yes, Mr. Chaudhary.
Worship, apparently, there has been lordship some because the reviewing officer and the accepting officer lordship is the same, whatever may be lordship. He has filed an appeal, though they are the same person. When an appeal goes, it goes to the IG Ops, and that has been rejected.
By the same person?
No, by a separate person.
No, you said
rank is same.
Rank is same. Rank is same. But
by the same office.
By the same office.
Person is different.
Person is different. Whatever may be lordship, but there is this thing that it ought to have been this.
Ought to have been?
The accepting officer, the reviewing officer cannot be the same lordship. That is the lordship.
No, so at the relevant point in time, who was the accepting and who was the reviewing officer? You tell us. And what happens if either one of them is not there? What are the who are the accepting and reviewing officer as per the circular?
Then there's the next lordship at page 54. 6.1.1. The ACRs will be initiated in duplicate by the commandant, principal, ADIG, being the controlling officers of the respective unit, establishment, institution as the
So the
case may be.
commandant is what? Reporting.
Yes. Initiated by commandant.
Then admin is here. Then
The
go to
will be
DIG.
sent to the range DIG and the operational ACR to the operational DIG. The range,
He appears to be the IGP.
No, my lord, the reviewing authority ought to have been the operational DIG.
DIG,
And the-
then it will go to the IGP.
Then accepting authority ought to have been the administration IGP. And the IGP ought to have submitted his report to the administration IGP.
Here they have missed out on one step. Because
No, not on one step, on two steps. Number one, he is signed as a reviewing officer.
he signed as the reviewing officer and he's also signed as the accepting officer.
As an accepting officer, it ought to have been signed by the admin IGP. He is the IGP operations. Unless you say that he was holding dual charge,
That means
which you have not stated.
that of course is not there in our affidavit lordship.
So, what is to be done now?
Lordship, since the remarks, the gradation, what he has to be graded as lordship are good, very good. That perhaps lordship would not be in the domain of this court.
Absolutely not. We are not supposed to tell them whether to be good
yes.
or very good.
Yes, but under the circumstances, lordship, the matter has only to be remanded back, lordship, because here they have
Remanded back where?
to the level of the lordship reviewing officer, lordship.
Where is the appellate order?
My lord, the appellate order is at page 93, my lord, annexure M.
93.
Yes.
This is on justification why he should be upgraded or why he should not be upgraded. But it is not on the procedure.
Who is the appellate authority in terms of this particular page 54? Is there any appellate authority?
My lord, as per the Honorable Supreme Court decision in Devdat, the appellate authority has to be one rank higher than the accepting authority.
Oh, tell us on facts.
My lord.
If I may take your lordship to page 66. In the CRP of the first representation, I guess adverse remarks in ACR of AC to IC lies at the level of sector IG, who is the head of the department for the sector units. Appeals against the orders of the sector IGs are referred to the DG, who is the head of the force. Some officers, however, also prefer appeals to the Secretary MHA and Home Minister, etc., against the orders of the Director General on their first appeal.
Where is the order of the appeal again? Appellate order?
Page 93. 93.
So he is obviously not the person prescribed under the rule. Under what is this? These are guidelines.
Yes, standing order number 56. These are followed as the guidelines. There is also a provision for second appeal, my lord. And we have preferred the second appeal before the highest authority, that is the Director General. And he too mechanically rejects my order. That order is at page 123. Conclusion is page 124, para 6.
Yes.
Now, therefore, after taking all aspects into consideration, I find no reason to disagree with the final grading recorded in APR of the officer for the period so. Accordingly, petition dated so preferred by Sri P.K. Tiwari, that is the petition 2IC so, CRPF Jorhat, is rejected being devoid of merit under the provisions of so.
Yes. Yes.
Both the appellate authorities did not take into account that there was a procedural left. The concerned accepting authority had no jurisdiction to act as an accepting authority. Those aspects of the matter was never dealt with. So my humble prayer is that, my lord, whatever records would be available, because it's an operational thing, and I was acting in the intelligence wing, some records would be there. So matter may be remanded back and have a fresh assessment and have a review DPC on the basis of that fresh assessment.
Yes, Mr. Dev Chaudhary.
Lordship, apparently this procedural aspect has not been taken into account
By the first appellate.
by
First and second.
the appellate authorities. Lordship, they have only dealt with the question of his APR, whether that would be accepted or not. Yes, that is for the authority to accept or not, but the procedure, Lordship, there is some. It may not make any difference in the
There are
final
no
outcome.
separate. There are no separate rules laying down the procedure for
Lordship, I have.
CCS, CCR.
So here, Lordship, this their own.
This is the what you call standing order.
Yes, Lordship.
Page, first page, Lordship, will come page 51. Next. Page 51, 51.
Yes.
1.1. The system of confidential reports on the performance of government servant is mean to an end and not to an end in itself. The ultimate goal is to optimize the achievement of government policies and programs. This is possible only if the confidential reports lead to the optimization of the performance of the concerned government servant. The main focus of the reporting officers. So these are the guidelines, my lord, followed for writing confidential reports and maintenance of those reports.
Okay. Yes. You are for the second matter.
No, person is same.
Same person.
Same person.
Then,
My lord, I'll be relying on that debtor judgment, my lord.
huh?
I'll be relying on 2008 8STC 725 debtor judgment.
Give a second file letter. You'll be relying when?
My lord, I'm now, my lord.
If you rely on the judgment,
Yes,
what do you
sir.
mean you will be relying on?
My lord, my lord.
If you are relying on, you supplicate the
I
judgment.
apologize, my lord. The book list to be at 2008 8
Yes, 2008 SCC.
2008 volume 8 STC.
Page number?
725.
Sorry?
725. Devdutt versus Union of
Devdutt.
India. My lord, two para I will be relying, para 9 and para 37.
37.
Para 9, the Honorable Supreme Court says any grading which does not earn me a promotion will be treated as an adverse minor. And para 37, the Honorable Supreme Court has held that the appellate authority has to be a one rank higher than the assistant court. May I read that para? Para 37. We further hold that when the entry is communicated to him, the public servant should have a right to make a representation against the entry to the authority concerned, and the authority concerned must decide the representation in a fair manner and within a reasonable period. We also hold that the representation must be decided by an authority higher than one who gave the entry. Otherwise, the likelihood is that the representation will be summarily rejected without adequate consideration, as it would be an appeal from seizure to seizure. That is my humble.
All right.
A very short issue in Lord Mellow. The consequence of a penalty, minor penalty, and its effect on seniority, restoration of seniority. This man was subjected to various.
Why are they connected?
Not connected, no, same person. That is why it was fixed. But ultimately, if he gets the relief here also, that will enhance his seniority. That is one connection is there. If he gets the seniority here, promotion here, then in my case, he will be much more benefited.
What order are you challenging here?
Page 120, Lordship will find the order of punishment. The relevant portion of the order of punishment. Page 120. Paragraph 10. Reduction of pay by 2 stages for a period of 2 years is imposed upon Sri PK as a petitioner, deputy commander, so and so, with further direction that he will earn increment. This is important. He will earn increment of pay during the period of such reduction, and on expiry of such period, the reduction will not have the effect of postponing his future increment of pay. That is the order of penalty, or he in fact has not challenged the order of penalty, and the currency of the penalty is also over. Now he is relying on the office memorandum, where it is stated that if the penalty order is not specific for losing of seniority, there are 2 OMs. One is at page 126. If the penalty order is if you're silent about losing its seniority, then he will regain his seniority on his subsequent promotion. So after that, during the currency of the proceeding, he was found fit. But since it was a currency of the proceeding penalty, the promotion order was not effective. Immediately after that, the promotion order was effective, but his seniority was not restored. That is the small issue. The office memorandum is very clear that if penalty order is not specific of losing of seniority, then he will regain his seniority on after promotion. OM starts at page 28, 128. And relevant portion also will find is page 130. After the three sub-paragraphs, thereafter, in case where the reduction is for a specified period and is not to operate to postpone future increment, the seniority of the government servant may, unless the terms of the order of punishment provide otherwise, be fixed in the higher service grade or post, or the higher time scale what it would have been but for this reduction. This is a reiteration of an earlier office memorandum. That was of that is at page 126.
Yeah. Now, where is the order of punishment?
Page order of punishment page
120. 120.
120.
120 is the operating of
It is the operative part.
starting at
the order starts from 111.
111.
All right. Now, what was the ultimate punishment imposed? Reduction of pay.
Yes, reduction of pay by 2 stages for a period of 2 years without cumulative effect, means will not have effect of postponing his future income. In fact, during the reduction period also,
There is nothing with the seniority aspect.
Nothing.
Then what happened?
Then, as per the office memorandum, he ought to have been given the seniority after his promotion. Immediately after the currency was over.
No. Is it a case that during the process of consideration of promotion, his case was in seal cover?
He was found fit, but promotion order was not issued because it was during the currency.
Yes. Then what do you say?
In fact, Malad, in the affidavit in opposition also, they have relied upon the same circular, Malad, page 43.
43.
Page 43 of the affidavit in opposition.
Yes.
Paragraph 4.2.2.
4.2.2.
Last paragraph.
In the last portion, my lord, in cases where the reduction is for a specified period and it is not to operate to postpone future increment, the seniority of the government servant may, unless the terms of the order of the punishment provided otherwise, be fixed in a higher service grade or post, or the higher time scale at what it would have been, but for his reduction.
Otherwise, if that is a clarification given by the
So he was subsequently promoted and fixed below his immediate junior.
lot. The seniority was not.
Yes.
But my lord, there is another aspect which needs to be considered in this matter. Okay, recommend 123.
120 punishment.
No.
What is their aspect?
No. My lord, kindly come. My lord, for this particular memorandum, my learned senior SS has referred to page 43. Now, I would like to draw the attention of this honorable court to page 40, my lord, and para 2.2.
Page 40.
Page 40, my lord.
45.
No, page 40, my lord. Or
40.
my affidavit in opposition. I'm referring to my affidavit in
No,
opposition.
don't
my
say
lord.
my and there. You refer
Yes, my
to
lord.
the
Affidavit in
continuous
opposition.
paging.
I'm
Otherwise,
extremely sorry, my lord.
page 40.
Page 40, my lord. It is the same memorandum that has been referred to by my learned friend.
Hmm.
Now, I would like to draw the attention of this honorable court to para 2.2. May I read, my lord?
2.1.
2.2, my lord.
2.2.
2.2. Where the promotion are made on the basis of the selection by DPC, the seniority of such promotion shall be in the order in which they are recommended for such promotion by the committee. Where the promotions are made on the basis of seniority, subject to rejection of the unfit, the seniority of the person considered fit for the promotion at the same time shall be the same as the relative seniority in the lower grade from which they are promoted. Where, however, a person is considered as unfit for promotion and is superseded by a junior, such person shall not, if he is subsequently found suitable or promoted, take seniority in the higher grade over the junior person who had superseded him. And this is the exact aspect, my lord, of this instant case. Because several times his promotion has been considered by the departmental promotion committee. But since he has been declared unfit, he was not getting his adequate post of promotion. And being aggrieved by that, my lord, this present petition has been prepared. And it is apparent from the various facts, my lord, that initially what has happened, my lord, his wife has lodged a criminal proceeding against him, so that the entire his service dossier has to kept in the seal cover envelope. And thereafter, he was charged with some articles of charge because of some misconduct done by him. Because he has threatened one of his subordinate officer and falsely
The reduction of pay
yes, my lord,
will reduce you into your rank.
No. Reduction of pay is a minor penalty. Reduction of rank is a major penalty.
Where is the punishment for reduction of rank?
No, not only reduction of pay.
Huh?
Only reduction of pay, not rank.
Then this clause that you are referring to is in respect where there is a punishment for reduction in rank, isn't it?
Again, I am reading on page 43 of the affidavit in opposition. This is much clearer.
Right,
In
page
cases
43.
where reduction is for a period and is not to operate the postpone future increments.
Reduction of what?
Reduction of pay. That
Yes.
is why increment word is there.
Hmm.
The seniority of the government servant may, unless in terms of the order of punishment provide, punishment order will have to be clear about.
No, that is what I'm asking. This
of
reduction
reduction of pay.
Reduction of pay, has it brought you down in your
Same rank.
same rank?
Same rank.
Then
Same rank, and prior to that,
does it define the seniority on the basis of pay?
No.
This is with regard
that
to
is
reduction of
reduction. They have not mentioned it.
Reduction for a specified period.
Specified period.
We'll take it that it is with regard to increments.
Page
my lord, this petitioner was not promoted because he does not come to the zone of promotion, consideration for promotion. This is the reason why, my lord. Because his APAR is inadequate to consider him promotion. That is the reason why, my lord. Pay is then correlated.
So this higher grade, higher scale, in your case, it will be a higher time scale, not post. Kindly come to 4.2.1.
Yes.
4.2.1 is imposition of penalty to a lower service grade post or a lower time scale. So, lower reduction to a lower service is one, which means you are demoted. Lower grade in the same post but lower grade. Lower post also demotion.
Demotion.
And lower time scale.
Right.
So perhaps in your case, it is lower time scale,
Yes,
stoppage of increment.
2 stages.
Now, once this is done, this will not be cumulative.
Not cumulative.
So after that, supposing 2 stages, you will miss out. On the 3rd stage, you will have to be given the benefit which you would have otherwise got.
Yes. Yes.
That is with regard to pay. There is the question of promotion or seniority.
Seniority, because these 2 years, I was found fit. My friend has said that I was not found fit. In fact, in the affidavit itself, page 4 of the affidavit.
No, then you have to challenge those discipline, this selection DPC minutes,
No,
DPC proceedings.
they found fit.
Huh.
They have stated
Huh.
page 4 of the affidavit in the position.
Page 4.
Lordship.
Page 4.
DPC last paragraph after the chart. Page 4 of the affidavit in the position.
Huh. So
Later, the
DPC
petitioner was found fit on 22. DPC convened on 22/6/2015. But at that point of time, it was during the currency of the proceeding. That is why my promotion was postponed for 2 years, because it was during the currency of the punishment of. So after that, I have lost 2 years of seniority. So I will regain that seniority. Otherwise, the penalty will be double. It will be double jeopardy. I will lose my seniority and pay both. That is why at
no, but under what provision? Under what provision were you found fit?
They say it is the DPC who indicated that though he is found fit, but during the currency of the penalty, his promotion cannot be effective. It is their stand.
My lord, DPC has been held almost every year. Now, in some of the DPC that has been held, it has been held by the DPC that he is not eligible for promotion. In some of the DPC, it has been held, Your Honor, 2 to 3 times that he is eligible for promotion or he come into the zone of the consideration for promotion. Accordingly, we have taken steps and we have promoted, and he is getting paid. His pay has been reduced because
He's referring to the last sentence of page 139. To be promoted after currency of the punishment mean for 2 stages you did not consider him fit, or if you considered him fit but you did not promote him. DPC was of the view that the punishment is for reduction of pay.
Referring to which page?
Your page number 4 of the affidavit.
Yes, my lord. Yeah. Yes, my lord. My lord is perhaps referring to the chart in this.
Below that.
Below. Then later, the petitioner was found fit by the DPC on 22/6/2015 for the vacancy period of 2015-16 with a rider to be promoted after currency of punishment, because at that time, my lord, he was punished because of some professional misconduct. Unless that period of punishment is complete, his promotion cannot be given to him. That is the point in this case, my lord. So, during that period, his promotion has been halted until his tenure of punishment gets complete. This is the point that has been asserted by this particular affidavit. Apparently, my lord, no injustice has been caused to the petitioner.
What is his punishment? Reduction of pay.
Reduction of pay, my lord. As pointed out by my learned senior, in the order that is.
Is it your case? Is it the case of the department?
Yes,
that if he is promoted to the next higher post, the punishment which was imposed for reduction will get nullified, because in the higher post means higher pay.
That is not exactly the case, my lord. when the DPC has been held for the year 2015 and 2016.
So the punishment was imposed in which year?
Punishment has been imposed, my lord,
31/12/2013.
2013.
And I was promoted page 122, 31/12/2015, exactly after 2 years.
Exactly after.
After 2 years.
After 2 years. The continuation of punishment is for 2 years, my lord.
So you were found fit at that point in time.
Yes,
So you're given promotion.
Given promotion, but the promotion is not an issue. Restoration of seniority.
No, your seniority is not affected by this. How is it affected by the punishment? There is no reduction of seniority in the punishment.
Only reduction of pay. Even he gets the increment.
By
As
the
per
DPC of 2015, my juniors or colleagues, they got the promotion. They work in
That is not under challenge. Is it
That is-
under challenge?
Yes.
That
that is-
DPC is under challenge.
No, DPC is not. DPC found me fit.
Huh.
DPC, I don't have any issue.
Huh.
DPC found me fit.
Huh.
But the DPC say,
See, it is like this. You are earning 100 rupees salary. In 2 stages, you will get,
80.
say 10 rupees, 10 rupees, 20 rupees. So the punishment is that for 2 stages, your increment will not be there. So till you reach that 2 stage, your increment will continue to be 100. After that, on the 3rd stage, you will regain whatever you have got. Means you will get perhaps 140 or whatever that amount is. Right? Insofar as the DPC is concerned, there is a punishment. You are undergoing a particular punishment, which is reduction of the increment at 2 stages. Unless it is completed, if the DPC considers you fit for promotion, will it not nullify the punishment given by the authorities? You will now move to the higher grade.
No,
Or you can
Suppose-
say that, no, I will continue to be in the higher grade, but the punishment of stoppage of 2 increments will continue.
no, my issue is not for monetary. It is the restoration of seniority.
I understand that,
2015
but you are not
DPC.
considered to be fit for promotion because you are undergoing a punishment.
No, they found me fit. Found me fit.
They found you fit, but that is what is reflected.
Yes, they found me fit, but since it was because fit means because they took the ACS of previous 3 years. Considering that they found me fit, but they put a rider that since you are under the currency of the punishment, you will not be given the and exactly after 2 years, my lord, they promoted me, but my seniority was not.
But this
Seniority can't be given because you are, although the word terminology you are found fit, but you are not given the promotion. You are not considered for promotion. So therefore, it is not a case that your papers were put under seal cover and disciplinary proceeding was going on, and DPC decided that, all right, we'll keep it under seal cover. Subsequently, when the seal cover is open, they found that there is no lacuna. In that case, you have a claim for a review DPC and get your seniority.
But here, my lord, the office memorandum is very clear that unless, my lord, there is a specific wording.
That's right. That wording in the punishment order is reduction of time scale.
No,
so the time scale will not go beyond 2 stages.
I found fit in the year 2015. My juniors, they got the promotion. They became senior to me. So if the seniority, if I lose the seniority, then it will be a double punishment. Reduction in pay plus seniority. It will be a major penalty then. So that is why, since it is related to pay, that is why this office memorandum has clarified the issue that you do not give 2 punishment. If the punishment provides that he will also lose his seniority, then
This office memorandum cannot be interpreted to that extent.
Uh,
This office memorandum is categorically with regard to the wordings in the order of penalty. If the order of penalty imposes reduction to lower scale, grade, post, lower time scale, it shall not go beyond the period specified, indefinite period. That is cumulative.
that page 126 is little, that office memorandum of 2007, paragraph 4, last line. 126,
Yes.
last line of the paragraph 4. Authority is also required to indicate in the penalty order whether or not the individual charged government servant would be eligible for restoration of grade, post, or service from where he was reduced, and his seniority and pay. So it will have to be, they will have to be, make it specified. And if it is not specified, then I will regain my seniority on promotion, not in the same grade, on promotion. And immediately after the penalty, I got the promotion.
No, my lord, the answer lies in Annexure B. My lord, I would like to refer to page 62, which is a part of the office memorandum dated 14 September 1992. My lord, may I kindly once come to page 62. Perhaps this particular clause give the answers to all the queries that we are into. My lord, may I kindly come to para 3.1. Page 62, para 3.1.
Yes.
May I read, my lord?
Yes.
If any penalty is imposed on the government servant as a result of the disciplinary proceeding, or if he is found guilty in the criminal prosecution against him, the finding of the sealed cover shall not be acted upon. His case for promotion may be considered by the next DPC in a normal course and having regard to the penalty imposed on him. This is exactly what has been done by the DPC, my lord. And the action of the DPC is completely consistent with the procedure prescribed in the memorandum.
Yes, Mr. Sharma.
Page 43 is very clear.
Huh?
Page 43 that I referred to earlier.
Page 43 of what?
43 of the affidavit in opposition.
43.
Just now, I read out my book. So, under any stage, my lord, the term of losing my seniority will have to be there. If
This
it
is of
great-
86, the subsequent OM will have to be considered to have overridden. This page 61 is of 92. The OM you are reading is 86.
61 relates, page 62, OM relates to a different issue.
See, it's a very simple issue. There is a departmental proceeding against you. You are found, the charges have been found to be proved. There is a punishment imposed. If a punishment is imposed, obviously your this will be a negative entry into your ACR, into your service records. So you obviously could not have been found fit during the currency of the punishment imposed. The interpretation which you are giving is with regard to the penalty order only. So the penalty order, if it says that you are reduced in pay, etc., you are reduced in, supposing a person is a reduction in promotion, reduction in his post, will he never be considered for promotion again?
Yeah, obviously he will be. But since it is a minor penalty is categorized in a different category.
No, but it is a penalty.
It's a penalty.
It is a penalty. It is confirmation of the charges.
If I lose my seniority, then it will be converted to a major penalty.
You have lost your seniority by virtue of the penalty issued in the departmental proceeding. Otherwise, what is the meaning of a departmental proceeding?
True, my lord. That is why, and I have, in fact, he has not challenged the proceeding also.
Then
He has not challenged the proceeding, but the resultant action is under challenge. What will be,
resultant action is because of the penalty.
because of the penalty, my lord, yes, my lord, penalty is over. Then what they need to do is pay spotedly. If, because the penalty order is silent about losing my seniority, then they will have to restore the seniority.
No, then how do you explain para 3.1 of the
This is
OM dated 14/9? This is come to the opening lines, subject promotion of government servants against whom disciplinary proceedings are there. This will apply to you.
No, that is also, in my case, that is over. In fact, the current DPC, because penalty order is of 31/12/2013. In between, DPC said in 6/2015, June 2015.
So you are covered by this OM unless you have
Yes.
to come out of this OM.
No, OM is, this is in a different context now.
Why?
Para, page 62, para 3.1.
Yes.
If any penalty is imposed on the government servant as a result of a disciplinary proceeding, or if he is found guilty in a criminal proceeding against him, the finding of the seal cover will not be acted upon. That is how the seal cover will be acted. His case for promotion may be considered by the next DPC in the normal course. That
Having regard to the
that has been done. That has been done in my case. After currency, they have opened it, or in fact, they did not make it seal cover. They made it open. No seal cover. So few months are there. So you will be given promotion after currency is over. And on December 2015, June 2015, they found me fit, and December they gave me the promotion. This is in respect of opening of a seal cover and giving a promotion.
No, it is not
This
specifically.
3.1.
So.
And that has been done in my case. In my case, they have not kept it in seal cover. Maybe they have kept it seal cover, but in the affidavit they have not mentioned it that it was kept in seal cover. But they indicated that you were, I was found fit.
My lord, it is mentioned that his record has been put into the seal cover. My lord, may kindly come to para 2, page 2 of my affidavit in
That will not change any scenario. Now.
My lord, still, point has been drawn, my lord. Page 2 of my affidavit in opposition, my lord. I'm reading the last two sentences from the bottom. However, as a criminal case under 498 of IPC filed against him by his wife was pending in the court of Chief Judicial Magistrate Guwahati, his assessment by the DPC was kept in seal cover as per the instruction on the matter.
No, that was
How is this relevant now? This is not relevant here.
That has been interfered by the honorable. That is
gone now.
2005.
That is gone. From the last OM, it is not clear that.
Page 62, Lordship.
I'm
clarifying it, my lord.
It is very clear that it shall not be acted upon.
Yes, they have not acted upon. They say that it was under seal cover or maybe open, whatever it is.
So then it says it shall be considered by the next DPC having in the normal course having regard to the penalty imposed.
In fact, what they did, my lord, it was my last part last part of my currency of the penalty, they held the DPC. It was currency was up to 31/12/2015. They made in June 2015. They made it is maybe seal cover, may not be seal cover. It is not not an issue. The DPC itself has indicated that since he is on a currency of the promotion, currency of the penalty, so promotion order may be issued immediately after the currency is over. The currency was over on 31/12/2015. So immediately they issued the order on the same day. Maybe 122 page. Page 122 is the order of promotion. 111 is the order of penalty, 31/12/2013, and page 122, 31/2015. I have been promoted.
Oh.
They are relying upon the office memorandum, the portion of the office memorandum at 3.1. That portion is over, so far as I am concerned. Three point one is the procedure.
You show us some authority on
Yes.
that.
Procedure to be
You show us
adopted.
some authority.
Authority, Malad, I don't know, because this office memorandum is very clear. I'll show it, Malad. I will place the case
Thursday,
law.
we'll take
Yes,
it up on Thursday.
Lord, Thursday.
We'll dictate your orders on Thursday.
Right.
Same orders. Let both the matters be placed together on Thursday.
Lordship, I have got one difficulty on Thursday.
Your
My
colleague will be there.
My colleague will.
Yes. Yes.
16 তারিখে
Placed on Thursday.
Deeply
For
applied.
orders for admission. You're right. Admission. Coming on Thursday for
I was just informing my friend, maybe the documents which he was required to produce are annexed with my affidavit.
yes.
Here, my lord, in this case, my lord, private respondent, my lord, my brother, my lord, step brother, also, my lord, sworn one affidavit before this honorable court, my lord, in our court premises, my lord, that is Annexa 6, page 23, my lord. That here, my lord, he has specifically mentioned that that after the date of my paragraph, my lord, that is page 24, that paragraph para 3 in the affidavit, that after the date of my father Abu Bakr Siddiq, I got the job, my deceased father, but due to personal difficulty, I am not able to continue the service, and I have no objection if my brother Saiful Islam, date of birth 27/3/97, son of so-and-so, joined the said service. And this was, my lord, this was shown here in the Guwahati High Court premises, my lord.
Why do you keep referring to the High Court premises?
Because, my lord,
does an affidavit sworn in the Guwahati High Court premises carry more weight than any other?
there is a dispute, my lord. That is, he has stated, my lord, opposite party subsequently denied it. That he, on blank papers, I put my signature. That is why, my lord, I have to specifically mention, my lord.
Signing here in the notary, how does it prove that
yes, my lord,
it was or it was not taken on a
I have
blank
also, yes, my lord, in government affidavit, my lord, they have, my lord.
Then we'll have to send it for evidence to be taken from the notary public, whether it was signed in the presence of the notary public or not.
He has not come, but there is a statement, my lord, incorporated here, my lord, paragraph in affidavit filed by the, my lord, government side, my lord, page 50, my lord.
Page?
50. In paragraph, my lord, 5. On 8/5/23, Asifur Rahman Abu Bakr Siddiq had submitted a complaint petition against Muhammad Saiful Islam, where the petitioner alleged that Saiful Islam had taken his signature on a blank stamp paper and made NOC and submitted the same at the police headquarters without obtaining his consent. And in reply, my lord, in my affidavit in reply, I have specifically mentioned.
You serve copies of name, ask him to appear here in court.
That's it.
You make him a party.
Yeah, already he is party.
He's a party here.
Yes,
He's a
my lord.
party here.
That
Service
is not
complete,
appeared.
my lord.
He's not appeared. In fact, Lordship, the inquiry report is based on 3 complaints, Lordship. One is his brother, Asifur Rahman, himself, Saiful Islam, and Sajeda Khan, one of his mother. And Lordship, in the inquiry, the depositions of all the witnesses are different, Lordship. All the witnesses, well, first thing, Lordship, Safiul Islam himself, he says that his mother is the first wife, and Asifur, that the other guy, took illegal signature of him and his mother on an affidavit, Lordship, by way of NOC, and the same has been placed before the authorities. Sajeda Khatun person is also same, his mother. On the other hand, Lordship, one Osimuddin Ahmed, he is a president of a society, Lordship, Ram Harisa Gaon Pasayat. He is basically supporting his uncle. Uncle means the elder brother of the Dickies, and because he is also one of the applicant, Lordship. Only because, and his person is that only because his age has surpassed the limit, Lordship, he cannot be considered. And this he has filed one, and Moqsed Ali, his uncle, submitted an NOC that Asifur Rahman, his brother, may nominate for the post for Sajeda Khatun receiving the pension. On mutual discussions, Sajeda Khatun also gave NOC for Asifur Rahman. Later, he came to know that Safiul Islam took illegal signature of Asifur Rahman without his knowledge on a blank affidavit. Then comes Moqsed Ali, his uncle. This guy also has the same person. Lordship, after that, person of Asifur Rahman is there. He says that his mother, Ruby Begum, is the first wife, and the mother, Sajeda Khatun of
So ultimately, what happened to the
ultimately in the finding,
application?
last part is that, Lordship, it is been stated that the affidavit, Lordship, Safiul Islam and Asifur Rahman, they both went to the Guwahati High Court and made an NOC by the deponent Susmita, one advocate, in the name of Safiul Islam, for appoint to the post at the office of the Commanding Soldier, Walpara, in the compensation ground in place of Asifur Rahman. That is the conclusion, Lordship. Now, the affidavit has been placed in the record, Lordship, by way of an affidavit. Signed by both the parties. This is also a part of the record, Lordship. And based on this affidavit, Lordship, this Safiul Islam has given and later to the DGP that as we have come to a settlement, so I may be given the job, Lordship.
I means
Safiul Islam.
Petitioner.
Petitioner.
So what is the finding ultimately?
Our finding is that they have come to a settlement. That.
So you consider his case? You consider his case? If they have arrived at a settlement, then pass appropriate orders. Yes.
Let me get the instruction, Lordship, in this regard.
What instructions do you require? You have conducted an inquiry, he has done it. Now you consider his case. What instructions will you get? What instructions will you seek? What instructions are you looking for?
No, basically, because this inquiry report is of dated, Lordship.
Then you bring it on record. We'll see.
Inquiry report, Lordship.
You bring it on record. Why?
7/2023.
Huh?
16/7/2000. Oh, 2 weeks, Lordship. Otherwise, Lordship, let me get the instruction by writing a letter to them, Lordship. As the matter has also already been settled among the brothers.
Have you issued the order recalling that? Yes, he was appointed. The brother was appointed.
Not appointed.
Not appointed, only selected, my lord.
Only in the list, Lordship, not appointed.
Your prayer is setting aside of selection and
Yes,
appointment.
my lord, earlier I made the statement, but here as it is evident from the affidavit filed by them, they have not given up.
He was selected.
Yes, selected.
There is a list prepared, Lordship.
Now he has withdrawn his selection.
Lordship?
He does not want to proceed with the selection made.
No, my lord, that was my lord, just put their names and in this way that list was immediately data came
You
appointment.
get instructions Friday.
Yes.
That is the thing, Lordship.
Friday. List on Friday, Mr.
Because there's already a selection list, Lordship.
Huh?
Already a selection list, and his brother is in the list. So
In terms of the inquiry
Affidavit.
conducted, what steps will the department take now? If he does not want to be selected, why are you putting his name in the select list?
Annex 7.
no,
Mr. Sharma
selection list is of
advocate
dated,
will
Lord.
obtain the instructions.
Selection list
Few
to
of the
order.
submission made before the court that pursuant to the inquiry conducted, the authorities have concluded that the private respondent and the petitioner has sorted out their dispute, and the private respondent has submitted before the authority that he does not want to be considered for compassionate appointment, and he would have no objection if his brother, namely the petitioner, is instead considered for appointment. Matter we listed again on Friday.
Coming Friday, Lordship. No, that will be too short, Lordship.
You are the police,
After Diwali vacation.
DGP of it.
not after Diwali. Is it on 15th?
And Lordship, this thing, this inquiry report and the affidavit came into existence much after the selection list, Lordship.
Very well, you get your instructions. 15, list on 15. Mr.
Okay.
H. Last page of the petition.
Must be.
Yes.
Only the rejoinder part. Last occasion, the learned senior counsel had argued pre-counsel, okay? First, that the charge was admitted by the petitioner. Now, in that regard, I just want to place that if he had not admitted it, because the procedure as prescribed under the rule is different. When a charge is admitted, the entire proceeding need not be held, Your Lordship, as per Regulation 38, Clause 3 of the rule. So, and there is no mention as regards any admission in the inquiry report also. It cannot be, Your Lordship, a case of it's a case of denial, Your Lordship.
Where is the inquiry report?
Inquiry report? Lordship. Page 55. Page 55, Your Lordship. The entire inquiry proceeded as a case of denial, Your Lordship. There's no question of admission. And also, Your Lordship may kindly have a look at Regulation 38, Clause 3. Regulation 38, the last part, Your Lordship will find. They provided further that the provision portion that is above the regulation number 39 provided further that then an inquiry need not be held if clause 3 the employee makes a voluntary admission of his guilt in his reply to the opposite trooper's notice. Even in the inquiry report, the question of is only an afterthought. It is only an afterthought in before this honorable court, this was pleaded, that he had admitted. And as regards the second, Your Lordship, submission, that we have challenged the constitutionality or the ultra virus of the regulation without any pleading, Your Lordship, that we are not challenging. Now, whether this regulation is holding the field or not, whether the regulation is having the statutory force or not, we are only on that, whether it will hold the field. The question of constitutionality here does not come. And it's a pure question of law. It need not be pleaded, Your Lordship. Whether the regulation they have relied on.
But if you are questioning the applicability of the regulation,
yes,
in a sense of saying that it is see, there are two ways to urge this applicability. Is number one, that there is a separate set of regulations, or these kind of cases are an except under these regulations, therefore not applicable. There, the question of the validity of the virus does not arise. But if it is a question that these statutes are no statutes in the eye of law, then you're questioning the very existence of this regulation.
Statutory.
So statutory provision you have to urge before the division bench, not before this court.
Constitutionality will come. It's not a statute, Your Lordship. First, it has to be statute.
You are challenging the virus.
First, it has to be statute to challenge. Then only I can go and
it is a regulation, but whether these regulations are not regulations under the what is the Rural Bank Act?
Yes, Regional Rural Bank Act. So that whether only if it is a statute, only then I can go and challenge it. Now the question here is whether it's a statute or not. It has statutory force or not. Only then I can go and challenge if it's ultra virus to the Constitution or the Parent Act. But here the question is as regard whether it will have statutory force or not.
Well, the only thing at this stage I would like to say, if my learned friend want to say certain things, it should be in clear terms. There must be pleading so that we can reply to it. Now, they did not say anything. And the regulation speaks very clearly in the first page, in exercise of power confers under section 30 of the Regional Rural Bank 76. The Board of Directors of Assam Gramin Vikas Bank, after consultation with the United Bank of India being the sponsor bank and the National Bank for Agriculture and Rural Development, and with the previous sanction of the central government, thereby makes the following regulations. So therefore, if you want to say some other things, you must spell it out in your petition. Unless you spell out, my lord, how we can meet what you want to say.
Where are the proceedings of the inquiry?
My lord, the entire record is with me. I am placing to your lordship. The original proceedings and the exhibits, these are all here.
You can mark the relevant portions with regard to
My lord,
this
that,
particular.
that I will. For my lord, I can place the original one. I made it photo. I have marked it in the rank in my lord. Your lordship can see. Both the my lord, the original records and the photostat I am placing. He opened the account. He himself introduced. He introduced with somebody else will have to introduce. For he did. He introduced himself.
These facts are not in the inquiry report. Nothing was brought in the inquiry.
No, this is the proceeding.
And
the entire
Your Lordship,
proceeding will say.
Penalty, as regards the judgments as place regard penalty. That question of penalty will come in only after the charges are proved. That's why I am not.
You have preferred an appeal also.
Okay, I prefer an appeal.
What was the penalty imposed?
Removal from service.
Which is the inquiry report?
Report, Your Lordship. Page 55, Your Lordship. So one page.
That is the report.
That is, yes. Page 60 is the removal order. Removal. And the appellate authority order is at page 65.
All right. Anything else? Yes. We are listing it again on 18th. We will pass orders on 18th. For hearing on 18th. Much councils have, records have been submitted to the court. 18 November.
Much.
Yes. Yes, any update on the SLP? As per the last order, it was submitted that an SLP has been preferred against the judgment and order rendered by the Appellate Court of Guwahati High Court in Writ Appeal 45 of 2014, within bracket Upen Das. Stop. The councils were required to apprise the court of the status of the matter. Stop.
It is still pending. It is still pending before the apex court.
It is
And
submitted
no
by
effective
Mr.
order has been
R.
passed.
Borpuzari that the matter is still pending before the apex court. Therefore, none, however, appears for the petitioner. Matter be listed after 6 weeks.
And so, like,
Mr. Chaudhary and MS Wenso appears on behalf of R.K. Talukdar, Mr. Chaudhary for PWD. Mr. Borpuzari for finance.
finance matter. Obliged.
May please, Lord, in this case, my lord, you will also be appeared on behalf of the state respondents, my lord.
Who?
My
This,
lord.
this court? Oh, not before this court. Before any other court without me, as it is submitted, that this court cannot take up this matter. Okay.
Finance department, taxation department, my lord. Always to Lord.
We thank you for bringing it to the notice.
My
Lordship, the instruction yet to receive, Lordship. Kindly accommodate some time, Lordship. I will bring the instruction and accordingly submit the affidavit in.
What is the issue about?
Issue is that, Lordship, due to continuous absence, Lordship, he was misconduct. He was removed, Lordship.
Why this matter is listed after so many years?
Yes, Lordship. Rule was issued.
Why in 2012 and then not listed? Why?
It didn't reach. Actually. It didn't reach. It was listed earlier, but it never reached. Unfortunately, nothing could be done.
Never reached.
Never reached. We had been here for a whole days.
You could have filed an application for urgent hearing. Even affidavit has not been filed.
Yes, Lordship.
Why? What explanation do you have for not filing an affidavit? 11 years.
Only operative order was, Lordship, on 30/10/2023. Sorry, 7/11.
Mr. Borua, what relief do you want today after 11 years?
Actually, it is. I can't say that it's a very good case.
No, good case, bad case is a different issue. What is your prayer here?
Set aside the removal dismissal order.
find it strange, 14/9/2012 rule was issued.
Yes.
The last order is 12/10/2023. What happened for 11 years? Are you suggesting that this matter was listed for 11 years, not called up?
Yes, sometimes, then sometimes.
Then we'll have
time
to
has
direct
been
an
taken,
inquiry.
of course, for my.
You get the records, Mr. Counsel.
Lordship, Lordship,
Get it by next week.
Lordship.
Mr. J.K. Goswami, learned counsel for the respondent, submits that records have not been, instructions have not come. So this court, it is seen from the order sheet that the rule was issued in the matter as far back as 14/9/2012. And thereafter the matter was not listed. Thereafter there are no orders till 12/10/2023. No affidavit has been filed by the respondents. So what effective orders do we pass now? Tell us. What for have you filed the petition?
For
As a counsel, is it not your duty to bring it to the notice of the court? For 11 years, the matter has not been listed.
It was mentioned, Lordship,
Huh?
even after mentioning the matter, it was listed and it never reached, unfortunately. Several occasions.
You get the inquiry report. Is it there?
Lordship, the inquiry report is not annexed to the petition, Lordship.
You get the inquiry report.
Lordship.
Let the inquiry proceedings be placed before the court on the next date fixed. List on 18th. 18th November.
Lordship, Counsel D. Gogo is on legs at Port 17. He would come back immediately after the current.
Yes.
Your Lordship, in this matter, Your Lordship has heard this matter in detail. The issue that Your Lordship had raised on the last occasion was that whether writ petitions, should the writ petitions suffer from delay or laches? The issue here is that Your Lordship, in the year 1989, there were 18 posts advertised.
We'll take it, we'll hear after some time.
Yes. Or Your Lordship, if it's convenient for Your Lordship, can fix a very short date, probably higher up in the list, if so convenient for Your Lordship. Then the matter can be disposed of on that day itself, the next day, Your Lordship.
We fail to understand why the councils are not, these are 2012-13 matters. You're trying to ask for early hearings in 23. Why? We don't understand.
No, I'm willing to wait, Your Lordship.
What effective orders can be passed?
No,
now?
the matter is still alive, Your Lordship. The matter is still alive. The petitioners are one rung junior to the private respondents. The private respondents have an ample amount of service time left. I also have my service period left. Your Lordship, if Your Lordship interferes in the matter, then I can be given my seniority from date of appointment and promotion of my immediate juniors. The matter is still alive, Your Lordship. In fact,
you are at liberty to go and file a suit and agitate it for as many years as you want.
No, in fact,
You
Your
come
Lordship,
before the court asking for exercise of extraordinary power.
in fact,
11 years, 12 years.
Not 11 years. In fact, the last matter, Your Lordship, is 2020. 3 years.
Anyway,
Yes.
let us have it on some other day.
Lordship will kindly fix a short date, Your Lordship. This matter is also pray before Your Lordship. The matter is
21st.
21st.
List on 21st November.
Okay.
Yes, Mr. Mazumdar.
This is a petition where we have challenged the termination of service of the petitioner after being subjected to a disciplinary proceeding. But, in short, what had happened is the petitioner had gone on leave, and while returning back to report for his duties, he was arrested by the GRP and kept in custody for some time. On being released on jail, he reported back to the department where he faced a disciplinary proceeding on 2 charges. One, that he was found in an intoxicated condition by the GRP. Second, that he did not report the matter of his arrest to the concerned authority.
Report the matter to?
Report the matter of his being put under arrest and being in custody to the concerned authorities, and therefore, after an inquiry was held, my lord, he was dismissed from service. Now, here, the grounds for challenge basically is the first charge that I was found in an intoxicated condition is not a misconduct as per the act and rule of the respondents, because they define intoxication on duty to be a misconduct. My intoxication, if any, was only during the period of my leave when I had not yet reported back for duty. First issue. Second issue, there was no proof in the Department of Proceeding to even remotely show that there was any report of my being under intoxication proof in the court of criminal. Thirdly, my lord, the second charge that I had not reported the fact of my being arrested is belied by their own statements, where they say that I had reported to the GRP, requested the GRP to report it to the appropriate authorities regarding my arrest. A man who is put under arrest and put into custody cannot by himself go and report, or he cannot directly make a communication with his appointing authority or his competent authority. He had made the request. The GRP has given a statement that he told us whom to contact. We have contacted and we have let the persons know, that is the officials, that the man has been put in. Third, my lord, the point of intoxication was never proved in the department. If Lordship allows me the charge sheet, my lord, the charges that Lordship would find. First, if Lordship comes to, my lord, I'm sorry, if there was a criminal trial also against me, because one of the allegations in an FIR was, in the FIR that was lodged against me, was that in an intoxicated condition, I had thrown one person off from the train. I had been acquitted in the criminal trial because the persons who were injured have themselves stated that I was not the person who did all this. If Lordship will have the original FIR which was lost while I was coming back from to join my duties at page 13. The other procedural lapses also I will point out, my lord. Page 13. One Shambhu Yadav lodges an FIR saying that humble application is that I, applicant so and so, had today on 27/7/2014 boarded Northeast Express from Anand Vihar along with my brother to go to my home, and he boarded the general bogie and took seats. 2 army persons who were in the same bogie said how we have entered this bogie and leave the seat immediately and get down. We both brother left the seat and sat in the gallery near the gate. Then the 2 armed army persons came after verbally abusing us, hit my brother so-and-so, due to which my brother fell out of the train near Bindoki Road railway station. I then stopped the train, pulling the chain and shocked, and my brother was seriously injured in his hand and he was bleeding and was unconscious. My brother was admitted to Sadra Hospital. Therefore, your honor is requested to lodge an FIR. This was given, my lord, and thereafter I was taken into custody. And Lordship would find on the next page, at page 15, my lord, is the order dated 5/8/2014. The FIR was lodged
on 27/7/14 and on 5/8/2014, my lord, I was released on bail at page 17, lordship. Second last paragraph, let accused so-and-so Anit Kumar be released on bail on each of them executing a personal bond to the sum of rupees so-and-so. Thereafter, my lord, I reported back to the unit, and at page 18, I had been placed under suspension. Whereas an order placing number so-and-so under suspension was deemed to have been made by the undersigned by this office order dated 8/8/14. Now, lordship will kindly see, the FIR was lost on 27/7. Prior to my being released on bail, the bail order is of 5/8. On 8/8, they had made a deemed order. Now, therefore, the undersigned in exercise of the powers conferred under clause so-and-so revokes the said order of suspension with immediate effect, that is on 26/8/2014. That is because I had reported back to the DP and the suspension order was revoked. Thereafter, my lord, the departmental inquiry was conducted, but unfortunately, those papers I have lost, and I have only annexed a copy of the departmental inquiry report. At page 19, lordship will find the first article of it. The inquiry officer.
This is under CRPF.
Yeah. Page 19, my lord, is the structured version. Point number 2, article number 1. That the aforesaid number so-and-so had committed an act of disobedience of orders as defined in section 11(1) of the Central Reserve Police Force Act in its capacity as a member of the force, in that on 27/7/2014, he was found at the Fatehpur railway station public place in a state of intoxication, which is suggested by the FIR and medical documents. This act of the employee is a serious and punishable offense under the provisions of section 11(1) of the Central Reserve Police Force Act 1959. For a moment, my lord, if lordship takes the Central Reserve Police Force.
CRPF. What medical documents were there?
My lord, immediately on my arrest, I was taken to the, they have annexed it, they available. I was taken to the medical, to the doctors also for an inspection, which is done immediately on arrest. There, they have said smell of alcohol. This Honorable High Court and other Honorable High Courts have also held, the Supreme Court has also held, smell of alcohol is not equivalent to intoxication, at least in a service dispute. If lordship would kindly have the CRPF Act. First, my lord, page 4, section 9. If lordship has the offences which are laid out. What could be an offence under the Act? More heinous offence. Every member of the force who begins, incites, causes, conspires to cause or join in any mutiny. B. Uses or attempts to use criminal force or commits an assault on his superior officer. C. Shamefully abandons or delivers up any post or guard. D. Directly or indirectly holds correspondence with or assists or relieve any person in arms against the state. Or who, while on active duty, disobeys the lawful command of his superior officer, deserts the force, being a sentry, sleeps on his post, leaves his commanding officer or post or party, quits his guard, picket or party, uses criminal force or commits assault on any person bringing provisions. K. Intentionally causes or spreads a false alarm. L. Displays cowardice in the execution of duty. Now, like none of these relate to any sort of intoxication. Section 10. Less heinous offense. Every member of the force who is in a state of intoxication when on or after having been warned for any duty or on parade or in the line of march, or the rest matter do not relate to intoxication or consumption of alcohol. Lordship will find every member of the force who is in a state of intoxication when on or having been warned for any duty or parade. Now, the incident which took place is an incident when I was returning from my leave to report for duty, to report to join.
But in any case, it is a what, less heinous.
In any case, ma'am. So the
Less
first
heinous
offense,
calls for what? 1 year or 3 months?
1 year or 2 months, they have referred to section 11, if lordship will find just below that, section 11. The commandant or any other authority or officer as may prescribed may, subject to the rules made under this act, award in lieu of or in addition to suspension or dismissal any one of the more punishments of any member of the force. And this has been interpreted by the Honorable Supreme Court to say that for any offense required, it can be dismissal, removal, or compulsory retirement, and in lieu of that, any of the other punishments can also be taken. So, and their framing of the charge itself, lordship will find this act of the employee is a serious and punishable offense under the provisions of section 11.1. Section 11.1 does not define any offense. Even if we go to the definition of offense given in the act itself, this act, even if proved, is what has fallen from lordship a less heinous offense, and what my argument is not an offense and not at all, because it is neither when I am warned or I am on duty. Either when I am warned for duty or I am actually on duty. Neither of the cases fit it. Therefore, it is not a misconduct which is defined in the act itself. I'll place judgment before this honorable court to show that if an act is not defined as a misconduct in the act and rules, then the disciplinary authority just cannot frame a mind to say that, okay, this act will also become a misconduct. That would be jeopardizing the service career of all the employees if such an act is allowed on the part of the disciplinary authority. So my first argument is that it is not an offense at all for which the inquiry could have been held, or it could have, even if proved, could have been held to be a misconduct. The second, if lordship would find, article number 2, that force number so-and-so Constable GD Anit Kumar of so-and-so has committed a misconduct in his capacity as a member of the force, in that while the employee was arrested by the GRP Fatehpur pursuant to case number so-and-so under section so-and-so, which the employee did not inform the department on his own and kept hidden. Therefore, this act of the employee is an act of grave misconduct of negligence towards his duties, orders under section 11.1 of the Central Legal Police Code, which is punishable under Rule 27 of the CRPF Act and Rules. For this, my lord, I will just lead lordship to page 22. I'm sorry, not page 22, page 23.
Of the?
Page 23, part of the inquiry report, statement of one of the witnesses.
Yes.
Post number so-and-so, ASI Militia Nukul Chand, lordship will have at the end.
Why don't you take us sequentially? So let us understand what are the evidences against you.
Matter, the other evidences. All the other evidences from the inquiry report. Matter, that page,
Where are there any eyewitnesses?
Matter, there could be no eyewitnesses because I was coming back from my journey from my home.
No. Who is this at page 21? Who is this Constable Gyan Singh?
Gyan Singh is a person, my lord, who serves in the CRPF and who received phone calls regarding my arrest from the arresting authority. Lordship will find post number so-and-so Gyan Singh.
So he was never an eyewitness.
He was not an eyewitness either to my arrest or to my being in an intoxicated condition or anything.
Okay. Then.
But he states that he has received messages from the concerned IG of that area to the effect that one person from the CRPF so-and-so has been arrested by the GRPF police, and the person had led the GRPF police to inform them. Lordship would find perhaps just before the Samidhan Sarkar, 1, 2, 3, 4, 5, 6 lines from where my lord Samidhan Sarkar starts, 6 lines above that, the sentence starts with night. And his suspension was revoked from 26/8/2014. Further, the witness said that he did not know whether on 27/7/14 he was found in an intoxicated condition at Fatehpur or not, because he was never taken alcohol in front of this witness. But he knew that the accused used to drink. The witness further stated that the accused did not inform about his arrest by GRP at Fatehpur or regarding his being sent to judicial custody either by phone or by any letter.
All right, then.
The second one, my lord, is Samidhan Sarkar.
Also similar.
Similar, my lord. Further, the witness stated that it was not within his knowledge whether the accused was found in an intoxicated condition or not. The accused had never taken any intoxication in front of this witness. Third, my lord, Divakar Nath says, apart from this, the third line from the bottom, apart from this, he stated that he had never seen the accused in intoxicated state, neither did he know as to whether the accused took any intoxication, and he also stated that the accused did not tell about his arrest either by phone or letter. Then comes Narwal, my lord, assistant commandant. SS Narwal, assistant commandant, said that he reached the GRPF police station Fatehpur as the presiding officer of the court of inquiry considered to find out the reason behind the arrest and remand to judicial custody took evidence of in Sub-Inspector Fulchan on 5/10/14. There, Fulchan, who was investigating officer regarding the arrest of the accused, said that when Constable Anil Kumar was arrested on remand, he was in an intoxicated condition. In support, he produced a medical report of Fatehpur District Hospital issued on 17/35 on 27/7/14. Apart from this, he stated that he could not collect no information from the GRP regarding attempts of Constable to inform his higher officials or office regarding his arrest. On the next page, my lord, comes number 23. Brijesh Kumar Yadav, Inspector and Officer in charge of GRP PS Fatehpur. Shri Brijesh Kumar Yadav, Inspector and Officer in charge, said that on 27/7/14, Shri Sambhu Yadav, son of Yugol Yadav, had lodged a written FIR that he was traveling with his brother in the general bogie in train number so-and-so Northeast Express. In the same bogie, two army men asked them to leave the seats and got down from the train. When the two brothers left the seat and came near the gate, both the army men came towards them using vulgar language and kicked his brother Sanjay out of the train. The train was stopped by pulling the chain. When the train stopped at Fatehpur, then he reached the train along with complainant. Then the complainant identified Anit Kumar and Ramdas Singh as the army men who pushed them. Both the accused were taken into custody by the employees of GRP. Anit Kumar was taken for medical inspection at 17:35 hours, which confirmed consumption of alcohol. The witness further stated that when Anit Kumar was taken into custody, he was in a dangerously intoxicated state and he did not attempt to give any information to any higher official regarding his arrest. Further, he said that it was from the identity card of that the posting of the accused could be determined. Further, the accused questioning him the incident that occurred in 26/7/14 and that he was not intoxicated and that I had given fax number of my battalion and that I had asked them to inform my battalion. The witness said that on 27/7/14 at 15:20 hours, CRPF sent a message that the Northeast Express was stopped midway and that the passengers were not allowing the train to move, and further said that we took the complete information regarding him and through our senior superior officers informed his family and service center regarding his arrest. He also presented medical report. The ASI Minister Mukul Chand said that around 10:10 hours on 20th/7/14, information given from the GRP police station Fatehpur and simultaneously from the office of the Inspector General Central Sector by communication number so-and-so dated that force number so-and-so Constable General Duty had been arrested by the GRP Fatehpur. A request was made from 48th Battalion to Group Center Lucknow to appoint a special representative to inquire into the matter and send a report. On 30/7/14, a communication was received from headquarters Central Level Uttar Pradesh through fax, which intimated that Constable Anit Kumar was arrested on 27/7/2014 in an intoxicated condition and alcohol was found in the medical report. On 8/8/14, order number was issued putting the accused under deemed suspension. Apart from this, by letter number so-and-so dated 1/8/14, a copy of the FIR was received from the office of the Inspector General CRPF Lucknow. On 14/8/14, F48 Battalion informed that the aforesaid constable being released from jail has reported to the unit. Then by order dated 26/8/14, the suspension was revoked and on 21/11, the memorandum of charges was issued.
So where is the medical report?
Medical report that they have given the affidavit in occasion filed by the respondents, if lordship would have. There at page running page, my lord, would be page 72, internal page is page 10 of the affidavit in opposition filed by the respondent. Page 10 of the affidavit in opposition. Running page would be 72.
Page 10.
The affidavit filed on 21/1/16 by Mr. Keval Singh starts at page 63.
Medical report.
Lordship has page 60, my lord, the affidavit. At page 72 is the medical report. I'm sorry, my lord, page 71 it starts. And that is a medical legal examination form for injured person. Your
Not
lordship
very, is there a typed copy?
my lord, if lordship has page 72, the handwritten part is also, my lord, quite legible.
72.
Page 72, my lord. Just below the table. At the table part, I will read, my lord. There is a swelling of so-and-so, right upper nose, lower so-and-so, left upper lip, left upper lip, and on the left scalp. Then lordship would find, it goes, the last sentence is, alcoholic smell found on expiration. Inside the table itself, my lord.
No, I'm unable to look at.
My lord, page 72, lordship, page 10 of the affidavit in opposition. There's a table drawn, my lord.
Yes.
Square table drawn. The last line of the table, my lord, inside the table,
No, that's what I'm saying.
alcoholic smell.
This is not very clear. It is not clear at all.
Interesting. They must have the original bit. And at the bottom of the page also, my lordship would find alcoholic smell from expiration. So the only test that was done upon me to find out whether there was a consumption of alcohol or not is alcoholic smell on expiration. No, I'll place judgment for this honorable court which says that this smell is not enough to hold the charge of intoxication. In fact, my lord, before the trial court, there was no allegation that I was intoxicated and I had thrown the person out. The only allegation was that I had pushed the person out from the train. And that judgment I have, my lord, that acquittal order also I have given.
Let us see misconduct again.
Misconduct. Section 9. Well, in section 9, there is no mention of either intoxication or consumption of alcohol. The first one is begins, excites or causes or conspires or to cause or join in mutiny. B, use or attempts to use criminal force on a senior. C, shamefully abandons or delivers up any post. D, directly or indirectly holds correspondence or relieves any person in arms against the state. Or who, while on active duty, disobeys the lawful command, deserts the force, being a sentry, sleeps on his post, leaves his commanding officer or post or party to go in search of plunder, quits his guard, picket, party or patrol, uses criminal force to or commits an assault on any person bringing provisions or other necessities, intentionally causes or spreads a false alarm, displays cowardice in the execution of duty, shall be punishable with transportation for life for a term of not less than 7 years or imprisonment and others. Less heinous offenses. Every member of the force who is in a state of intoxication when on or after having warned for any duty or on parade or in the line of march. The admitted position is that on that particular day, I was coming back to report back to duties after my leave had expired. So none of the conditions of either being on duty, having been warned for any duty, or on parade or in the line of march is fulfilled. First. Second, the medical report simply shows that there was a smell of alcohol. The point of intoxication is never.
What about J?
Madam?
J.
J. With intent to render himself or any other person unfit for service.
No, no. J under section 9.
Displays cowardice in the execution of duty.
No, J in section 9. Section 9.
I'm
J.
sorry, madam. Uses criminal force or commits an assault on any person bringing provisions or other necessaries to camp or quarters, or forces a safeguard or breaks into any house or other place for plunder.
Okay, this is only for to the camp.
To the camp, when it is related to camp, or when I am on duty, if I go to any place, I use force to make plunder. Plunder is to acquire the wealth of plunders or destroys or damages property of any kind. These are none of the charges. These are not the charges against me. The charge is that I was found in an intoxicated condition in a railway station. Then lordship will have at L, knowingly furnishes a false return or report on the number or state of any man under his command or charge. I am not there. And all this, my lord, from M, absence himself without leave. N, is guilty of any act or commission which, though not specified in this act, is prejudicial to the good order and discipline, contravenes any provision of this act for which no punishment is expressly provided, or who, while not on active duty, commits any of the offences specified in E to L of section 9.
Yes.
Good. The additional affidavit that I had filed, my lord, I have put on record the judgment passed by the trial court, which tried me for the regarding the FIR lodged. There, specifically, the two informants have stated that they cannot identify me. I was not the person who pushed them out of the train, and they had not lost the FIR. And there is no allegation of me being intoxicated inside the train, because even the Railways Act, boarding a train under intoxication is one of the offences. The FIR lodged or the charges framed against me before the trial court does not contain a charge that I was in an intoxicated condition when I was recovered from the train.
Okay.
And the other procedural, the procedural.
You show us the judgments. Some date, some other date. Give a date. Thursday. Thursday will continue. Thursday.
Thursday, my lord, 16, my lord.
Thursday.
Oh, I think yes, my lord.
16.
No, Thursday is 9th, man. Day after tomorrow, Thursday. Yes, ma'am.
9.
Yeah, yes, ma'am.
9.
Yes.
Yes, Mr. Borgo.
Item number 29, admission hearing, my lord. There is an interim order till today, my lord.
Oh.
So we state a proceeding particular facts and circumstances.
Okay.
Proceeding, I may have before vacation extended it till today, my lord. If your lordship desires, my lord.
29 is for hearing.
Yes.
There is an interim order till today.
Till today. There are two orders. First order.
Is there any vacating petition?
No.
No, in the midway, earlier interim order was rejected. No. But last two occasions it was.
My lord, Immediate. And my lord, meanwhile, in spite of your lordship's stay order, they have, my lord, imposed a punishment on me, my lord. Peculiar, for which, my lord, I have.
You have to bring it on record.
No. I have already filed a separate challenging this also, my lord. And there has, my lord, kindly see the hostility, my lord, from this.
So this interim order with is regard to what?
Proceeding, your lordship stay.
But they have imposed punishment.
Impose, kindly see. My lord, one cannot be more hostile than my lord. I said, give me my, you have stopped my increment. They said, your proceeding is before High Court. So instead of filing a miscase, my lord, naturally I challenge that particular order, my lord, by way of a separate petition. And
Then
this came,
both these matters be connected together.
no, my lord. This matter, in fact, came, my lord, before Honorable Justice Jameel, my lord, in court number 2. The other lawyer, he is not appearing. They have different lawyer for the same respondent. He prayed for, lordship said, no, I'll pass order giving you a last chance on 9th of this. Lordship refused to take
That
it.
particular petition is in respect of increment purpose. And this petition is in respect of
proceeding.
Not proceeding. Initially, it was for the pair for change of the inquiry officer. That was already done.
Then we'll have it on 16th.
After Diwali, my lord.
16th.
After Diwali.
List again on 16th. The request of the
Because tomorrow the other case is already before his
Mr.
lordship.
Borbora is with petitioner, Mr. Gogoi is for the respondents. This is to be listed separately. The other matter is not to be connected.
16th is a problem. So, calendar isn't it?
16.
Yes, 16.
There is no calendar this side.
Yes, it is there, but half part.
16th is the
Other calendar.
it is worn out, my lord, at the fag end of the year.
All right, we'll get new calendars shortly.
Fag end of the year, my lord, worn out.
Yes. All right. On 16th.
If your lordship desire, my lord, lordship may observe 16 again, my lord, I might have to extend it until further.
The interim order passed earlier will continue.
Continue. All right.
28, we'll have it on some other day.
Let it be in the next week.
Next week? 16?
That's fine.
16.